Yes.
Maybe Your Lordship.
Yes.
Lordship, in respect of item number 25, I am the informant, my lord. Yesterday I filed affidavit, my lord. Maybe call for my lord.
Okay.
But Lordship, and I have yesterday, day after previous day, Lordship, I have mentioned Lordship for withdrawal a petition, Lordship, and the supply item number 51 wrongly mentioned, Lordship, and I have supposed to mention the one allocation of that is transfer petition. So wrongly mentioned the today's Lordship and withdrawal.
Who has wrongly mentioned?
One petition, Lordship, that is item number 54 of supply list.
54 supply. Yes, what happened to this?
Wrongly mentioned, Lordship, for withdrawal. Actually, it should be continued, Lordship, but
Huh?
wrongly mentioned, Lordship,
Who has wrongly mentioned?
your Lordship. Yes. I have supposed to mention another transfer.
So what kind of mention you make then? You wrongly mention a matter for withdrawal.
So I have supposed to mention transfer petition, Lordship. Mention, Lordship, this petition. Sorry, Lordship. So there is new petition, just I have taken step, Lordship. But
So what is to be done now?
should be continued, Lordship. We'll proceed.
Huh?
We'll proceed this case, Lord, petition.
You mention a case for withdrawal that was wrongly mentioned. I mean, what kind of things you do? Right, Mr. F. Hawk, the learned counsel. You are
FOP.
F. Hawk, the learned counsel, appearing for the petitioner submits that the mention that the criminal petition 1007-2026 has been wrongly mentioned for withdrawal. He submits that he wishes to withdraw, he wishes to continue with the incident case. Registry to list the matter in usual course.
29 was fixed, Lordship, last October. 29 was fixed date, Lordship.
I don't know what registry will do. Whatever it is. And don't do this kind of things. This creates problem and confusion. Should be careful about all these things.
Sorry, Lord. And the prayer, Lordship, and for listing a transfer criminal petition, Lordship, for day after tomorrow, can it be?
No, not day after tomorrow. In the next week. Transfer petition. There is no urgency.
Published, Lordship.
May I please, Lordship? Lordship, item number 14, Lordship, daily list, adjourn for this matter, Lordship, due to the, adjourn for the matter, Lordship, item number 14, daily list. 1-4.
You are?
R. Wrong, my Lordship, petitioner. With the concern of the other side, Lordship.
Your name?
R. Wrong, my.
You are not there in the case.
I'm there, Lordship.
Item number 40.
No, Lordship, 1-4.
1-4, okay. Your name is?
R. Wrong, my Lordship.
Your name is not there. Okay, the other matter is there. Okay, on the prayer of MS R. Rongmei, the matter stands adjourned.
Lordship,
To be
next week,
listed,
Lordship.
after 2 weeks.
May I please, Lordship? Lordship, I think item number 46 and 47, my lord. 46 is, in 46, my lord, I am appearing as amicus for one of the appellants. And my learned friend, Mr. S. Dotto, appears for the other two appellants, my lord. He is not available today, my lord.
46, 47.
46, so, my lord, as a joint prayer, my lord, matter may be adjourned, my lord.
Okay, on the prayer of the learned counsel, Mr. S. Nawaz, the matter adjourned and to be listed on,
My lord, 11th of August, it was.
to be listed on 11th August,
I'm deeply aware.
2022.
Both 46 and 47.
46 and 47.
May I please, your Lordship? Lordship, I have to mention for listing, matter was last posted on 15, my lord. On that day, CD was not received. Matter may fixed on 20, my lord. My lord, yesterday, my lord, it was not listed, my lord. So, my lord, it will come tomorrow, my lord.
Not tomorrow, next week.
My lord,
Next week.
My lord, already matter was fixed, my lord.
Hmm?
Already matter was fixed yesterday,
Hmm.
but
Then you go to the registry and find out why it was not received. You go to the registry.
May I please, your lordship?
Yes.
May I please, lordship? Your lordship, with regard to item number 17, lordship, I'm for the petitioner. Lordship, in this case, we had challenged the FIR, but it has come to our information that the charge sheet has been filed. Therefore, we are seeking liberty to bring the charge sheet by way of an additional affidavit, your lordship. On record. Item number 17, lordship.
On the prayer of the learned counsel appearing for the petitioner, the matter is adjourned and to be listed. When do you want it?
So after 4 weeks, your lordship.
After, to be listed after 4 weeks.
Highly approved.
May it please, your lordship.
He submits that he has already intimated. You are appearing for the petitioner?
Petitioner, lordship.
Okay. He has already intimated the counsel for the respondent number 2. You have intimated,
Lordship, I have not intimated.
Hmm?
I have not intimated, your lordship.
you have? Then you should have intimated,
I apologize for that, lordship. Because of the development, your lordship, I had,
but you should have intimated.
I will do it now, lordship.
Okay, then don't cut that line.
Grateful, lordship.
May it please, your lordship. In item number 55, my lord, there is small typographical mistake in the type copy of the
Hmm?
FIR. In item number 55, my lord,
Hmm.
there is one typographical mistake in the type copy of the FIR. If lordship permits, I may be allowed to correct by hand, my lord. One word.
Not by hand, not by hand,
Hello.
not by hand,
No, lordship. Let the matter.
not by hand.
No, lordship.
We'll adjourn this matter or will
Not-
you take it up?
Only one word.
Okay.
So Lordship, I beg to mention for listing of the matter on 22nd, Lordship. The person is behind the bar for more than
22nd,
Yes, Your Lordship,
today is what?
21, 21st.
22nd, it
Tomorrow,
will be
that is.
difficult. 22nd, it will be difficult.
Your Lordship,
What is the urgency?
Lordship, he has been behind the bar for more than 3 months, Lordship.
More-
without any
more than?
trial. More than 3 months without any trial, Your Lordship.
More than
More than 3 months, Your Lordship.
3 months,
Yes, Lordship.
without
Without any trial, Your Lordship.
any,
Trial.
this has been charge sheeted.
Yes, Lordship.
That is not a sufficient reason. Let the matter be next week,
Next week, any date may be given.
next week, you go to the registry and like list it out.
Did you-
may I please, your lordship. I wish to mention item number 19, my lord. I have taken consent from the other side, my lord. The matter may be taken after 2 weeks. my lord.
On the prayer of the learned counsel appearing for the accused applicant, item number 19.
19.
Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after 2 weeks.
There is an interim, my lord.
Interim order so passed earlier shall continue till the next date of listing.
All right.
May it please your lordship. Lordship, I beg to mention one pending bail application for withdrawal, my lord, if tomorrow at the end or tomorrow. Deeply obliged.
May it please, lordship. Lordship, I beg to mention for listing of bail application day after tomorrow. Or
Yeah,
Friday.
tomorrow not possible, next
Friday,
week,
lordship.
next week. Next week.
Item number
Problem.
27, my lord. May it please your lordship, my learned senior counsel M.A. Mondal has some personal difficulties. Kindly grant adjournment in this matter.
Okay, 27 on the prayer of learned counsel appearing for Mr. M.A. Mondal, the learned conducting counsel. The matter stands adjourned and to be listed in the next week.
Next week,
May I
Next
please-
week.
like your lordship.
May I please, your lordship, I beg to mention item number 36, lordship.
Hmm.
Is due
Yes.
to, matter may be examined for a day, lordship.
36,
36.
36, lordship, charge sheet submitted.
charge sheet is submitted in the matter. Let the matter come. You are there. I mean, who is Alhazuddin? The charge sheet has been submitted. We'll dispose it of when the matter comes.
Lordship, I beg to mention item number 15, my lord.
Hmm?
Item number 15, my lord.
15.
Yes, my lord. With the consent of the other side, my lord, kindly pass.
I am for the respondent number 2, my lord. It may be fixed on next week, my lord.
Okay, on the prayer of the learned counsel appearing for the petitioner, which is not opposed by the learned counsel appearing for the respondent, let the matter be fixed on 4th of August.
Problem. May it please to your lordship, with the consent of other side, I beg to mention item number 53, Lordship, in this case, I am for the petitioner. We are going to file Ukalatnama today. We have recently engaged,
Okay,
kindly come,
your name?
R.K. Mohanto.
Mr. R.K. Mohanta, the learned counsel, appearing on behalf of petitioner
Yes, Lordship.
and appearing on behalf of the petitioner submits that, that he has been newly engaged in the matter and will file the wakalatnama today. He submits that, he prays that the matter to be listed after 2 weeks. He submits that he has already taken the consent of the other side, counsel appearing for the other side. Let the matter be listed after 2 weeks.
Highly obliged.
May I please, Lordship? I beg to mention for listing IA Lordship in criminal petition, criminal appeal Lordship for bail Lordship
Next week,
on 28th of,
Hmm?
28th July Lordship.
20th July, next week.
July, Lordship.
Please, Lordship, I beg to mention an anticipated bail for listing Lordship. Lordship, there is a reasonable apprehension that the person will be arrested, Lordship.
That
And-
is always there in
Lordship,
anticipatory bail.
It's a heart patient,
Hmm?
Lordship. But in the
Everyone is having a heart problem these days.
Lordship, it's a genuine case, and Lordship, and we had filed it last week, Lordship.
Hmm.
Already 7 days has passed, Lordship. Still now it has not been listed,
So
Lordship.
when do you want?
Lordship, tomorrow, Lordship.
Okay. tomorrow.
May I please, Your Lordship? I'd like to mention item number 16, Your Lordship.
Hmm.
I'm on behalf of respondent number 2, Your Lordship. Yes. My phone voice was at- One voice was at-
You intimate the other side counsel. He's sitting here only. He's senior to you. You should have that much of courtesy. He's sitting there and you are not telling him beforehand.
Lordship,
Why?
I did.
You have not been taught these things by your senior?
Lordship, I was
That
taught-
somebody who is senior to you, or whether senior or not senior, but somebody is sitting here, you are mentioning the matter, you should tell him that I'm going to mention the matter. He's sitting here only.
I beg your pardon, Your Lordship.
On the prayer of the learned counsel appearing for the respondent. Respondent number
Item
two.
number 16, Your.
Respondent number two.
Yeah.
Respondent number two. The matter stands adjourned and to be listed when?
Need it as per the convenience of the court, Your.
After 2 weeks. After 2 weeks.
Obliged.
The prayer is not opposed by the learned counsel appearing for the petition.
Oblige, Your Lordship.
Regard 36, I may not, our meeting is there, so your lordship may pass that because. item
That charge sheet matter?
Yes.
Okay, we'll dispose it of.
Fine.
Yes.
Number 14, again, I have to mention, my lord, that my learned friend from the opposite party is my lord, respondent. To mention, my lord, for after 2 weeks, maybe, my lord. But
It has already been mentioned.
my lord, but there is an interim order that may be continued.
Interim order so passed earlier, shall continue.
My lord, I'll leave.
May I please, Your Lordship? My lord, this is regular bill application, my lord. I am behind the bar since 29 days. FIR is at page number 14. Relevant portion is at page number 16, my lord. 16. So far, the FIR, nothing recovered from my possession, my lord. The contraband recovered from the house of Liakotali. 29 days, my lord.
Intermediate quantity lordship, let the CD come.
We'll call for the CD.
My lordship.
Heard Mr. So-and-so, the
Yeah, fine.
learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the APE for the state. Then you write, this is an application, you write, then call for the CD, let the matter be listed. Mr. Sharma,
Short date.
3rd of August, lordship.
3rd of August.
Highly obliged.
My lords, I'm behind the bar for last 1 month. My lords, the FIR, it is to page number 11, my lords. With due respect, I beg to state that I am the secretary of the Patuli Gaon Panchayat. I came to know from the local people that Mohammed Idris Tali sons of the Shahadul Tali of the Patuli village to have loved relations.
Heard
with
Mr. So-and-so, learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APB for the state.
The married one. my
This is
lords,
an application.
That's the alleged victim is the affidavit filed, my lords, in this case. The alleged victim, she has filed the affidavit, my lords.
So,
The victim is the wife of the accused persons, my lord, stands she is now about 19 years, having a child.
so we'll see the CD. I mean, it is a POXO matter. It has been registered under POXO. You know that in a POXO matter, that notice has to go. We'll have to hear the other side. Heard Mr. So-and-so, learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. This is an application under so-and-so.
Will it count with file minutes, my lords?
Issue notice to respondent number 2. In term, as per the notification, government notification, as per the prevailing notification issued by Gauhati High Court. Notice to respondent number 1 dispensed with, call for the CD, let the matter be fixed on.
Just shortly,
Third of August.
3 my lords.
3rd of August, Lordship.
Hmm?
3rd of August.
3rd of August. 3rd of August.
From Khetri, my lords, state sorted.
I mean, everybody has their urgency, Mr. So, but 3rd August is perfectly fine, I think.
Well, it's a arms act is there, madam, diary will be necessary.
Okay, heard Mr. N.J. Datta, learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. This is an application under so-and-so. Call for the CD. Let the matter be fixed on.
It's 7th of August.
Can it come 5th? Well, 7, I have some.
5th.
I'm obliged.
Madam, for. And it's a substituted matter, madam. Notice is to go since it's a matter under POCSO. So scan copy of the TCF may be called.
Okay, heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP. Is an application. Then issue notice to respondent number 2 as per Gauhati High Court. This thing. Then you write 1 dispensed with. Call for the registry to call for the scan copy of the TCR in connection with POCSO case number 62/2026 pending in the court of which court?
Special just POCSO Morigaon.
Special Judge POCSO Morigaon. Let the matter be listed on 7th of August.
Lawsuit.
POCSO matter, Lordship.
Same
May I
order,
please, Your Honor?
POCSO matter. Huh? Same order.
Petitioner is
Here,
arrested.
Lordship, CD will be required, not charge. sheet.
Kali only thing is the CD, huh? Call for the CD. Listed on 9th. 7th August.
7th.
7th August.
7th. Same Lordship, POCSO matter.
POCSO. CD.
CD.
Right, same order. Huh? POCSO matter, CD, call for CD.
7th, Lordship.
7th.
7th.
Madam. 1 month has completed, madam. Under Immoral Traffic Act, public has taken them this to the police station and they were arrested, madam.
Okay, we'll call for the CD.
Lordship.
Heard Mr. S.C. Biswas, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned AP for the state. Then this is an application. Then you write call for the CD, let the matter. be fixed on.
Whether the special officer was specially empowered, that report is also required.
That they will submit, let's see. Immoral trafficking, you'll have to take instructions on that.
7th.
Only the matter fixed on 7th. It was not Mr. Biswas. It was, I mean, he didn't go to that place and raid it and arrested those persons. Only thing is that like the public has took them to the station, police station.
In the night, madam, and 35-4 also, areas of.
No, no.
Without
the-
magistrate's power, madam.
Correct. I mean, he is not arrested them. Public has taken him to the,
But he was investigated the take a matter, the case, madam.
that we'll see.
That's why, madam, special empower is required. Madam.
May I please your lordship?
Mm.
Dear lordship, the FIR is at page number 19. 3 persons are named as accused person, lordship. The
Mm.
present petition is for accused number 2, who is the father-in-law of the alleged victim, my lord.
Mm.
page number 19. This is lordship, basically lordship marital dispute between the accused number 1 and the alleged victim. Page number 19 is the FIR. Second paragraph, my lord. I was married to the accused number 1 in January 2020, and our marriage was notarized on so and so. Shortly after the marriage, I discovered that my husband, accused number 1, and his family member are actively involved in illegal drug trade. My husband frequently brings drug customer into our home, and on several occasions, these individuals have attempted sexually harassed me in his presence. My father in the accused number 2 has subjected me to physical and mental torture since the beginning. He repeatedly forced himself upon me, attempting to engage in sexual acts against my will.
You are accused number 2.
Accused number 2, my lord.
So we'll call
Now,
for this.
Lordship, kindly for a moment, page number 28. This is the case filed by the accused number 1 against the alleged victim, lordship. That case was filed on lordship 5/6/2026.
We'll look into this. I mean, you have, there are serious allegations in the FIR. We'll just have a look into this. And heard Mr. M. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APE for the state. You are being,
For informant.
Mr. So-and-so, S.S. Sharma, appearing for the informant. This is an application, right? Then you write call for the CD. Let the matter be fixed on.
He's a government employee.
Let the matter be fixed on.
7th lordship from Dhubri.
He's a government employee teacher. May I pay for a short time, if otherwise continue?
Yeah, I mean, against the teacher, that this kind of allegations.
That is lordship after losing the lordship restitution of conjugal right. She has been living separately since.
Okay, let the matter be fixed on 5th of August.
Hello.
Item 9.
For equity appreciation, page FIR is a page 18. But what happened in the month of October 25, some traders from Rupohi went to Patharkandi to purchase the battle nut. So there was a deal of rupees for 20 lakhs. 6 lakhs have been paid, 14 lakhs will remain as a dues. Thereafter, now they have went to the Rupohi, Shibhumi, and demanded the money. Then, actually, I was a mediator. I know both the person, all that you take credit. Now, police is asking me to attend the police station.
So go and attend what is there.
I want little protection from your lord.
He was assaulted and presently is admitted in hospital. That part is also there.
I was only mediator. I have no role. That all right. They will pay the amount,
He is the accused number 1.
Mediator are the most difficult persons.
But
Everywhere.
I am not interested in money transaction, nor I have.
You are not interested. You are not interested in transaction. You are only a so-called holy person. And try to help out people. Help out people.
Holy person. But the fact is that I have mediated all right. You pay later on. Now they are not paying.
One second.
I am Raju Ahmed, After my 8 months, 9 months, the FIR was lost. Now police asking me.
Heard Mr. S.C. Diswas, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APP for the state. This is an application under section 482 of BNSS 2023, praying for granting pre-arrest bail to the accused applicant in connection with Atawari PS case number 179 of 2025 under section 61 in bracket 2 stroke 318 bracket 4 stroke 309 bracket 6 stroke 127 bracket 2 stroke 351 bracket 2 of BNS 2023. An FIR was lodged by one Imamul Haq, Normal Hawk, before the officer in charge of Atawari Police Station on 26th and 2025, alleging inter alia that he, along with some other persons, went from Nagaon, went from Gauhati, Nagaon to Patharkandi on 17/10/2025 for purchasing local areca nut. That semicolon, that after reaching at Patharkandi, one Raju Ahmed, in bracket you write the accused applicant, came with his Maruti Suzuki vehicle and took them to the house of Nuruddin at Kutulpur. That when they reached the house of Nuruddin called 6 unidentified persons and they asked them to give them the key of the vehicle, and they assaulted them and assaulted them. Then you write that they took the vehicle key from the accused applicant and took away rupees 14 lakhs kept inside the vehicle. That due to the assault, one of the persons sustained severe injuries and presently he is admitted in hospital. On receipt of the FIR, police registered report Atawari PS case number 179 of 2025 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant is no way linked to any kind of assault in the instant case, and in fact she is one of the mediator who tried to settle the deal. He submits that because of the filing of the FIR, he is apprehending the arrest, and therefore the instant application has been filed praying for PRS bail. Taking into account the facts of the case, this creditors of the considered opinion that some interim protection should be given to the accused applicant. Accordingly, it is directed that in the event of arrest, the accused applicant by the arresting authority, he shall be released on bail he shall be released on interim pre-arrest bail on furnishing of a bail bond of rupees 30,000 with a severity of like amount with a satisfaction for the arresting authority, subject to the condition that the accused applicant shall appear before the investigating officer within a period of 10 days, and he shall fully cooperate with the investigation by making himself available as and when called for by the investigating officer. And next part, call for the CB. Let the matter be listed on 5th of August.
Item 10.
Senior counsel Mr. S. Student speaker in this pass out to the matter time being met.
11.
May please alone. Capital Act matter. FIR is at page number 14. 4 numbers of capital were allegedly recovered in the vicinity of the petitioner's house. So they suspect that the petitioner is running a slaughterhouse. That is the only allegation.
Who suspect?
Policeman.
Hmm?
FIR has been lodged by one SI.
Police doesn't suspect. Police knows everything.
But there are no materials, madam. They are only suspecting that he is running a slaughterhouse. And apart from that, nothing has been recovered. Any byproduct or anything.
Heard Mr. S. Das, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned AP for the state, decision application, so and so, call for the CD, let the matter be listed on 4th of August.
Well.
4th of August.
Hello.
Well,
Your Lordship,
Hmm?
preceptory bail application. FIR is on page number 15, 16, Your Lordship, 15,
15.
1-5.
Hmm.
Your Lordship. May I read, Your Lordship? 1-5 in burning condition.
Heard MS so and so, the land council appearing for the accused applicant, also heard B. Sharma, the land APP, reason application under so and so, call for the CD, let the matter be fixed on 5th,
Interim, Your Lordship.
no interim.
Okay, please, Your Lordship. Followed the FIR at page 9, my lord. He has received notice, my lord, under section 35(3), my lord. But he was in Hyderabad, my lord, therefore he could not appear in time, my lord, as per the notice.
Okay, heard Mr. A.M. Borbian, land council appearing for the accused applicant, also heard Mr. B. Sharma, reason application, call for the CD, let the matter be fixed on 5th August. 5th of August.
My lord, police also primarily arrest does not feel necessary, my lord, therefore notice is issued for it. Notice is issued when, my lord, arrest.
No interim protection. You go and appear.
My lord, as per notice, my lord, if he cannot timely appear, my lord, then, my lord, arrest may be.
Correct, that's why they will see the CD.
But my lord, please also, my lord, not primarily inclined to arrest.
I passed the order, Mr. Borbian. I have looked into the matter. I mean, I've seen the allegations. And I have seen the gravity of the offense alleged.
But
And
police
after
also, my lord,
after that,
primarily-
I have seen the gravity of the offense that has been alleged, and after that, we have passed the order.
but police, my
Okay.
lord,
himself is not, my lord, inclined to arrest him, my lord, prima facie, my lord. But if he cannot appear as per notice, my lord, then, my lord, police may arrest. Therefore, my lord, I before your lord.
You go and appear.
But,
You
my
go
lord,
and appear.
it is provided in the notice and the act also, my lord, he cannot appear, my lord, if in the time, my lord, he cannot appear. My lord. As per, my lord, act, my lord, section.
I have passed that order, Mr. Bowman. I have seen that. Then after seeing that only I have passed the order.
Read to your lordship. Lordship may kindly record the last order, lordship, 14/7/2026, lordship. Notice was served upon the respondent number 2 on 10/7, lordship. And none appeared on that day on behalf of respondent number 2. Today also, lordship, none appeared.
So will I appoint somebody? What is the case?
We are seeking default bail, lordship. Under POCSO, lordship. On the ground that though the charge sheet was filed within time, lordship, it was not laid before the honorable court within statutory time. Just put up beyond the, after the.
CD has come.
Scan copy.
Scan copies, okay.
Then if Lordship is deciding the default bail aspect, then Lordship, I would like to place some judgment and the matter may be fixed at 2. Provided he doesn't argue on merits, Lordship.
No, I will not argue on merit, only on default.
Only on default bail, then Lordship at 2. I will also place some judgment, Lordship.
What is your argument?
So although the charge sheet was filed within time, lordship, the charge sheet was not put up before the court below on within time.
How do you say so?
Because the order sheet reflects the lordship and the.
Where is the order sheet?
I have annexed the order sheet, lordship.
Page 21.
Page, lordship, 23 onwards. 21, lordship. The first order, lordship, he was produced before the court below. Then, lordship, I have annexed the entire order sheet and it is also there in the record, lordship. The order sheet.
So we'll take it up at 2 o'clock then.
Yes.
Let's see.
Right.
21.
The regular bail application. But the issue here is, my lord, non-production of the accused person matter before the other magistrate within 24 hours of this action matter. So lordship will kindly see the FIR, my lord. The lordship will find that page 12, my lord. FIR is dated, my lord, 9th of June 2026. And my lord, relevant portion regarding his apprehension part, so lordship will find it page 14, my lord. My lord, second paragraph.
One
After
second.
subjecting to brief interrogation of all the accused persons, they
One
disclosed
second. Where you're reading?
My lord, page 14, second paragraph. That part, after subjecting to brief interrogation.
Yes.
All the accused persons, they did disclose that Mukesh Ali bring large amount of NTPS.
After subjecting to brief interrogation, all accused persons, they disclose that Mukesh Ali bring the large amount of sum and over the same to his brother so and other associates who are responsible for selling those in small quantity to various so. On completion of all formalities, we departed along with the party from PO at 4:50 a.m. and arrived at Itacholi TOP at 5:30 a.m. on 9/6/2026. 9020
From morning 5:30 a.m. persons are in the police station now. So this 24-hour period will start, my lord, from 5:30.
We arrived actually at 5:30 a.m. on 9/6. Yes.
So, my lord, this time starts from 5:30 a.m. of 9/6.
Hmm.
Now the forwarding report at page 17, my lord. they were produced before the magistrate on 10/6/2026. So even if they are produced in the very first minute of the working hours, that will be 10:30 a.m. It will be beyond the 24-hour period. And they have shown the arrest at 9:30 p.m. at night, so as to enable them to produce on 10th. But custody starts from the moment they take the police. Otherwise, a strict direction from this honorable court that when the accused is produced before the magistrate, the IO as well as the magistrate must report the time at which the accused is produced. That has also not been complied with. But otherwise also, it could not be at 5:30 a.m. of 10/6. It has to be during court hours. So it will be after 24 hours.
It may not be in court hours, it's not necessary that it should be in the court hours.
It has to be at 5:30 a.m. in the morning, Now, case diary is there. If they can show from the
They
case
can,
diary.
bring them at any time to the magistrate police.
Now, there is a direction from this honorable court
Hmm.
to all the magistrates and all the police officers so that this confusion does not come up, to reflect the time in the remand order as well as in the forwarding. That has not been complied with. But from the case diary.
No, if that is not complied, is it a violation?
No, but if the period
And-
is after 24 hours, if it is after.
No,
24
fine,
hours,
there is a direction given, but if that direction is not complied with, does that give you a right to get?
My
something.
submission is like that. My submission.
Yeah,
is
I
that
understood your
within
submission.
the-
I understood your submission, but where is the direction of the court?
This is judgment of this honorable court.
What direction has been given?
On the same issue of. If the same issue had come up, the judgments of this honorable Supreme Court were examined. And if your lordship will kindly come to the paragraph 24, 20, 30, my lord.
Here also issue was the same.
Same issue.
What is there in the CD?
Lordship. In the arrest memo, it is stated that Lordship, he was arrested on 9/6/2026 at 9:30 p.m. Lordship. And if I look into the FIR Lordship, they received the information at 12:30 a.m. at on 9/6 Lordship. And they have went away from the police station at Lordship, 2:30. 2:30.
2:30 AM.
2:45 AM.
Hmm.
And the distance also need to be covered, Lordship, the traveling distance also has to be taken out of this 24 hours, Lordship. Moreover,
No, distance cannot be taken out just like that.
but it is there, Lordship.
What is that?
In within 24 hours, the traveling.
Then the
period-
direction is given that like nearest, if you cannot produce within 24 hours, then you should take a transit, permission for transit.
Transit remand. But here, मतलब same jurisdiction, same police station. Moga police station. And the address is also the same, my lord. Itasali, my lord. So from 5:30 AM, we are in the.
But arrest is 9:30 PM as per the arrest memo.
But as per the judgments, my lord, the Honorable Supreme Court, the moment they are taken into custody, my lord, the 24-hour window starts. Sir.
The arrest memo shows the time of the arrest, no other document.
But then, my lord, their FIR itself shows that they have been in the police station since 5:30
On
AM.
9/6.
They must have been brought for some interrogation. That doesn't mean that they have been arrested.
But they have categorically stated that they have apprehended.
See, interrogation doesn't mean, somebody can be called to the police station and interrogated. Doesn't mean they have been arrested.
Judgments on this.
This is the entry of 9/6 Lordship.
Hmm?
9/6, dated 9/6/2026. The entry, all the entries, Lordship. I have given to Lordship.
12:30 AM. Then 2:45. But what happens after this 11:15 AM? 11:50 AM on 9/6, 6:03 AM. You have, police has taken the statement of the accused persons at 10:20 AM, 10:50 AM, 11:15 AM. Then what happens after that?
Caesar witnesses have to be.
Caesar witness, they have been examined before that. Then what happens? Then what is the explanation till 5 PM? 5 PM, there is no explanation. You check properly and check properly. See, whatever, the place of occurrence, they went at midnight.
Okay.
They recovered those articles witnesses were there.
Lordship.
Then as per this, I mean, they have taken the statements of witnesses and everybody, and that was completed by 11:45 PM, 11:45 AM. 11:45 AM on 10/6, not 9/6, 9/6. 9/6 or 10/6, just check. Next day will be 9/6. No, 9/6 AM only, on 9/6 only, 9/6 only, same date. So 9/6, by 11:45, you completed everything.
No.
Then why arrest was done at 5 PM?
I have to look into that. Lordship.
What happened to that, huh?
I will have to look into that, Lordship.
You look into that.
Lordship.
I have two judgments, my lord, Honorable Supreme Court, my lord. First is Dinesh Kumar, my lord. The lordship will kindly come to para 21, Dinesh Kumar, my lord.
Para 21.
21, my lord. 21 onwards, my lord. This issue, my lord, when the arrest is deemed to be made, my lord. May I read, my lord?
Lordship, if I said the Lordship, at 9/6/2026, Lordship, at 8:30, they interrogate all the accused persons, Lordship. Then there is a note, Lordship, on the same time, 8:30 PM on 9, Lordship. It is to be noted that after getting the statement.
8:30 PM, 8:30 PM, 9.
9 on 9/6, Lordship, at 8:30 PM.
Huh.
They interrogated, and then Lordship at 9:30, they have stated that now I have arrested the accused person. They have clearly stated that, Lordship. Now I have clearly arrested the accused person, Lordship. All the persons are named, and after found sufficient evidence against them and kept them at, this is the day, Lordship. And that is the last date of entry is 9, Lordship, on 9, and the time is 10 PM. And on 10th, Lordship, on 10 AM, they have stated that I have proceeded to the place of occurrence, Lordship. Then, along with the accused person's, Lordship, and accompanied staffs have, they have gone. And 10:20, they have stated, it is to be pointed out that after LFL, I have drawn the rough sketch map of the place of occurrence, which is enclosed here with lodge. They went to the place of occurrence, rough sketches were made along, accused us along with the police lordship.
Before production.
Before production, these things are done, lordship.
When at 10 PM, they have arrested.
At lordship, if I be precise, lordship, to be precise, at 9:30, they have arrested.
9:30. So
9:30
9:30 to 9:30 in the 9:30 PM.
lordship.
Okay. 9:30 AM will be 12 hours only.
No, then they next date is lordship 10:06.
So at what time they have produced?
Lordship, they have stated that now I, along with my staff, left for Nagaon to produce the 3 arrested person with proper, that is on 2 o'clock. And at 3, lordship, now I, along with my staff, arrested had arrived. 3 o'clock they have arrived.
3 o'clock they have produced.
Produced, lordship.
Hmm.
If I look into the entry, lordship.
Look, one thing becomes clear that time of production before the magistrate is 3 PM, 10:06. So your lordship will 10:06 is judgment by.
But they have arrested on 9:30, lordship. The thing is that, lord.
So where is the conclusion ultimately?
My lord, the conclusion here is that, my lord, in paragraph,
Page 27, what does it say?
no, the conclusion your lordship will find at, starts from paragraph 27, my lord. The moment the person's personal liberty gets curtailed, my lord, from that period.
How you will say that liberty is curtailed? If he is willingly sitting there and cooperating with the investigation?
Here they have
No, see, there are two things. I understand what Supreme Court has stated. But there may be something like this, a person has been taken or taken to the police station. And he voluntarily wants to disclose certain things and like he wants to sit there with the police. And whether that will be detention or curtailing a personal liberty.
Had the police issued a notice and they had voluntarily gone, it would have been a different case.
No, that's a
Here-
different thing. Otherwise also you can accompany them.
Here they have gone.
If
to-
somebody is found with narcotics and if that person is asked by the police, come with us to the police station, we want to have the informations. And if he goes there, he doesn't have any problem in going there and he discloses certain thing and he sits with the police and cooperates with the police and sits there. Then after all this, I mean, whatever the investigation or I mean, like whatever questioning and all these things, he was voluntarily doing this. Then wait for here for a minute. Voluntarily doing this, then later on found out that okay, this person should be arrested. The police arrest him. Whether it can be said that like his personal liberty has been curtailed.
Here in the FIR, they have very specific.
No, you answer my question. Whether that situation can arise or not.
Well, that's
Only because he has gone to the police station, only because he was sitting in the police station, does it mean that his personal liberty is curtailed?
my submission.
Whether he asked to go out, is there any evidence that he wanted to go out, but police was not allowing him to go out?
I'll also rely on the other judgments on this point, but my respectful submission before your lordship is that they have very clearly stated that they have apprehended us, man, in the FIR at 5:30 AM. They have apprehended us and taken us to the police station, man. So when apprehension is there from their side, my lord, it is not a voluntary appearance on my part, my lord. The other two judgments should also, my lord, perhaps address this issue. Subhash Sharma judgment also, my lord. Para 6 on. Para 6, 7 and.
Yes, the other case,
Subhash Sharma, my lord, para
Hmm.
6, 7,
para 6.
7 and 8, my lord.
Out here, he was detained by issuing the LOC. So there was no, I mean, like dispute about like detaining him, about his detention.
Detail,
Hmm.
and he was handed over to the
Hmm.
customs authority.
Hmm.
So physical custody was taken over with the customs at, my lord, 11 o'clock at 5th, my lord.
Hmm.
They subsequently showed the arrest at, my lord, 6th of March.
That is different because here, clearly LOC was issued, then he was handed over to the, handed over. So in that case, the detention is not disputed.
Here, my lord, the physical custody was assumed.
Only thing is that arrest memo was issued later on,
Later.
later.
Like in this
In this case also arrest memo was shown, I mean, it was shown to be on a, on a time later on. But
this here also, my lord, in this case, the physical custody of the accused persons was taken at 5:30 a.m. And my lord, our coordinate judgment, my lord, clarifies all of these issues, my lord. Kiran Singha, that I have given, my lord. That, my lord, para 11 onwards, all of this has been checked, my lord.
I only want to state here, Lordship, though he was at first, his house was searched, this contraband has been found, commercial quantity. Then, Lordship, he has been interrogated, Caesar witnesses has been interrogated.
But you have apprehended him, mister.
Lordship, otherwise, Lordship.
You have apprehending means what? Apprehending means you have taken them into basically basically in custody initially. Then you have taken them to, I mean, clarified, na, custody, and have you gone through these cases?
Lordship.
Huh?
No.
You have gone through these cases
Not
which
really.
he's been relied on.
No.
So it has been clarified. So in that connection, I mean, only issuance of the arrest memo on a later time, on a later time, you can't say that like because he was shown arrested in the arrest memo, this thing. Because you have already apprehended. The word apprehended as you have used. You basically need to educate your police officers. See, state of Assam is having the minimum conviction only because of this. And I mean, time and again, we are seeing that because of the lapse of the police officers, I mean, lot of things are happening. Conviction is not happening. Nothing is happening. The lowest conviction around 7% or 8%. Otherwise, the state of Haryana and then Delhi and all this is 78%, 79% conviction. What is happening?
They're just trying to, Lordship, to gather them evidence first, then they.
No, these are the statutory things. These are happening from so many. I mean, it's there in the CRPC for. I mean, so many years, but still your officers are not aware of this.
They have done the.
I mean, that too arresting people caught with narcotics, huge quantity of narcotics. So something should be done. I mean, I don't know what is.
Currently, Lordship, I wanted to state that they, in the arrest memo, 930 is there, Lordship. And they have been, after that, they have interrogated the Caesar witnesses and accused persons.
You hand over the CD, I'll pass the order later.
Lordship, much obliged.
Deeply obliged, madam.
Look, very one side,
Please, Lordship, can it be taken up after some time? Senator is on legs, Lordship.
CD has come.
Yes, Lordship, here I would submit, Lordship, no need for lengthy argument, Lordship. Considering the progress of investigation and the development, Lordship, it can be considered, Lordship. I'm just submitting, Lordship.
Why? What has happened?
No, Lordship,
I mean,
investigation has progressed substantially, Lordship.
Hmm.
And all the seized documents are under verification. Their signature have been obtained. So that is my submission, Lordship.
so you don't want them inside.
57 days, Lordship.
Hmm?
Already 57.
The allegations are also quite,
Allegations are there.
I mean, quite lengthy. So accordingly, they have been put behind the bars for a lengthy period. Huh?
Let it be after some time.
Much obliged.
May I please your lordship? One of the prisoner was arrested on 24/5/2026. Today is 59 days. That is 2 months, my lord.
CD not received, Lordship.
59 days.
Yes.
And matter relates to?
Matter relates to, my lord, the rape, my lord, a married lady, my lord. As well.
90 days.
Yes.
Hmm?
Yes.
As per case registered, that is nice.
Then what else we are going to consider now?
My lord,
As per the case register only, we'll see 90
Yes.
days or 70
Yes,
days.
ma'am.
Or is there any other ways to see, look into it?
yes, FIR was lost after
No, no.
21 days delay, my lord.
No, that's understood. But like you are saying, as per the registered, then what else we are going to consider other than that?
My lord, the ground of delay, my lord, may be considered because such a case, my lord.
Yeah, delay, forget
lady-
about this.
A married lady, my lord, lost the affair. Can it turn to the page 9, my lord? I am reading the affair, my lord. Most respectfully begs to state that taking the advantage of my husband absence from the last 6 months, the person named below has been proposing me for establishing physical relationship with me. When I rejected this proposal, he began abusing me with slang words and threatening to rape me. And on May 2, 2026 at about 2 p.m., while I was cutting grass for the goat in the field.
Okay, what is there in the CD?
CD not received,
You
Lordship.
did not receive.
The answer, Lordship, this statement was perused by the court below, Lordship, and after perusal of that.
Then we'll wait for the
Yes,
CD.
Yes, Lordship.
The CD not received. Let the matter be listed on 4th of July,
4th of August, Lordship.
4th of August, sorry.
25.
CD received?
And this was issued.
Lordship, charge sheet submitted.
You go there? Okay, heard Mr. Ayub Chaudhary, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned AP for the state. Then you are appearing?
My lord, I am the
Correspondent.
informant. member.
So and so for your name?
M. Hawk.
M. Hawk for the informant. This is an application under so and so. Then you write that Mr. B. Sharma, learned APB submits. The CD in the charge sheet in the instant case has already been filed by charge sheet number
112/26 dated 17/7.
So in view of the aforesaid submission, the learned counsel appearing for the accused applicant submits that and that liberty should be given to him to approach the jurisdictional court for appropriate relief. Accordingly, the instant bail application is disposed of with liberty granted to the accused applicant to approach the jurisdictional court, if so advised.
Deeply.
26, Lordship, CD not received.
Case there is not received, none appeared for the petition accused applicant when the matter was called for. CD not received, let the matter be listed on 5th of August.
Lordship, can it be on 7th?
7th of
From
August.
Digrugarh, Lordship.
28.
CD not received, Lordship.
Page 11 is the FIR.
CD not received.
The CD not, but here is a case, where the petitioner was granted interim bail in a different case, as because of his wife.
Now we'll have to go through the CD in this case. CD,
Or that maybe
Mr. SM Abdullah P is present for the petitioner. For the accused applicant, then we write CD not received, later matter will be listed on when?
6th of August.
Huh?
6th.
6th. 6th.
Can it be
Earlier than that, no, not possible.
Because YCD
60 is fine.
was granted in.
A CD needs to be perused and
Total years final, but
we will fix it at fourth.
obliged money.
Yes, Mr. Anand B. Chaudhary. CD received.
Yes, sir.
No, no, go.
Yes, sir. My lord, in this case, my lord, petitioner was arrested, my lord.
CD has come.
Yes, ma'am. 26/6/2026.
Let us go to the FIR.
Yes, my lord. Ask your lordship kindly go to the FIR. My name is not mentioned in the FIR. Lordship, FIR is page 15. Complainant legal existence.
FIR is at 19, page 19.
FIR 15.
15?
15 lot.
Or 19 is forwarding, yes.
Where existence, I, Masudda Huza border Bolton was specifically submit and receive a specific verification drive were conducted, different date, lost Polton Bazaar, Gauhati and RR Guest House, Satyabari, Polton Bazaar. I am the owner of RR Guest House, my lord. Gauhati jointly by officer border force and Panbazar police under the supervision of senior officers. During the course of this, 23 persons were detected who disclosed themselves to be national of Bangladesh were found residing in the aforesaid establishment. Preliminary inquiry further revealed that apprehended person were in possession of Aadhaar card. That is important, man. And other document genuineness and the matter of procurement which require detailed investigation because they have produced some Aadhaar card and other document, my lord, identity proof. On the basis of that, they are allowed to stay there, my lord. The detection of such large of Bangladeshi nation two separate establishments within a short span of time indicate the possible existence of well-organized network not eliciting illegal integration. Transportation, harboring,
So,
central-
well, you have been arrested on 25/6.
Yeah, 25/6, my lord,
Mm.
and 26 is forwarded. That is the MC.
Your name is
My name is, my lord, Samsul Haq, my lord.
Samsul Haq.
I'm the owner of RR Guest House. Actually, it was run by a
RR Guest House located at
It's the Serapati, my lord.
Sarabhatti.
Yes, my lord. RR Guest House situated at Serapati. And my lord, there is a manager, my lord. Manager is allowed to go on PR bond, my lord. I am the owner of Guest House. The manager who people come, my lord. And some of Allah and other take these people, my lord.
People come and go, but you are not a responsible citizen. That's why you have allowed some people, unauthorized people to stay there.
Suppose I go to the, my lord, airport. What do you say, document, my lord? There is a mechanism, my lord, to verify it, my lord. There is no mechanism to verify it, my lord. That is the problem, my lord. If there is a mechanism, my lord, suppose I produce my driving license. How can I verify, my lord? In the airport also the mechanism, my lord.
See, after looking certain persons, you can make whether these persons are suspicious or not. Can't you do that? Then on suspicion, you can verify the documents.
Document I produce.
And what is there in C?
Yes,
Yeah,
Lordship.
but for I might get my punishment.
Firstly, I want to state here, Lordship, this is a serious case, Lordship. Here in one, there are two.
How is it? His case is very simple. He's saying that
I will.
he's only the owner.
No,
Other
Lordship.
cars were produced and
No,
I have
Lordship.
allowed them to stay there.
No, Lordship. I will
Then
go
what
in-
is there?
I will go into that, Lordship.
Mm.
Firstly, few minutes, Lordship. Firstly, there are two houses, Lordship, RR Guest House and one is Body Lodge, Lordship. Two houses. In one house, in his house, Lordship, this 11 persons were found where Bangladeshi nationals, Lordship, and 12 are in Lordship that are guest house, body lodge, Lordship. And the Aadhaar card has been found to be fake. And moreover, what he is asking, Lordship, that what evidence, other evidence has been found. It is there, other evidence are there. It is learned that the accused, this person, Lordship, facilitated SIM cards with his own credentials, which is a gain to heinous crime, Lordship. And he does help the illegal immigrants to stay in this state. Maybe there, Lord.
Madam, may I submit my one thing, my lord?
But if you have given your credentials to get SIM cards, then this court is not going to allow you.
See, kindly look to
This court is not going to allow you, Mr. NNB Chaudhary, if you are giving your credentials to procure SIM cards. No way, no way.
Naked, Lordship.
Well, I am-
All these persons are, and
No.
some of them are the middlemen also, Lordship. They are
I
also
have
working.
the additional affidavit, my lord, to that effect, my lord. Whether because I have taken the instruction, my lord, there is no
Further,
that
in
is
the-
provided.
I have
One has write down one line, my lord, that is why I shall file additional affidavit, my lord, to that effect, my lord.
And he cannot keep on filing additional affidavits to that effect. What is there, this court will decide the matter on the basis of the case diary and nothing else at this stage. This is not a trial.
I may submit, my lord. I am not producing any
The
document. That
last
was I
few
am
lines,
asking,
lord.
my lord. Whether you give me the document, no document has been.
Further is there, lordship, further.
So, my lord, your lordship, kindly give me some.
the middle,
I shall
lordship.
file an additional affidavit stating that, my lord.
Not required, Mr. Chaudhary.
That is, my lord, important because someone write down one line, sign down. then, my lord, my
Investigation
deadline
is
will be
going on,
accepted, my lord.
lordship. There are racket is going on.
My lord,
They bring illegal migrants, lordship, to this state of Assam, lordship, and they also provide shelter.
my-
Foreigners Act is also there, lordship.
my lord.
It's a
whether
serious case,
government
lordship,
is
much serious
serious
case.
To take the Bangladeshis, my lord, detention camp has been, my lord. They have all break the detention camp, my lord. Everything done, my lord. NRC, nothing has been done. I am not doing all these things, my lord. Whether they have, why they have break the detention camp, my lord, or broke all the detention camp, my lord.
We are not at all concerned with
That
those,
is-
Mr. Chaudhary.
Submit that. I have never provided this document, my lord.
That trial will decide.
My lord.
That trial will decide, Mr. Chaudhary.
Think whether for the purpose of investigation my detention is necessary.
Yes,
What
this
the
is very
difference?
much necessary. You are running a racket.
Lordship.
You are bringing in those, illegal immigrants, giving them shelter. You are giving your credentials to get SIM cards. And you are saying you are a responsible citizen. Don't please.
My humble submission before your lordship is that, my lord, I am admitting one point, that people come, produce the document. So far credential is concerned, my lord, I take the instruction from him.
I will not go with your instructions. I'll go with what is there in the CD. And this is an investigation stage.
After some time,
No, no, no.
after some days, my lord, I shall argue before your lordship, my lord.
If you want to argue on merits, if you want some time, that can be granted.
Yes,
But
my lord. Your lordship
But
can
but
grant, my
don't come up with an additional affidavit saying that
Yes,
no,
my
no,
lord, yes,
this
my
and
lord.
that.
Your lordship can
Don't come up
grant,
with this.
my lord.
Huh?
Some time, my lord.
When?
Well, my lord, I am, after 5, I am available, my lord.
No, not after, this week. Tomorrow, day after tomorrow.
26 तारीख.
Tomorrow, day after tomorrow. If you want, I can give you some time.
My lord. Yes.
And moreover, lordship, he himself stated that the accused person, there are the Bangladeshi persons are there. He himself stated that in his statement.
Yeah, I have gone through the CD.
Look,
I have seen
I
this.
say so this. This तारीख लो. Can it be up 23?
When?
23.
23rd, okay. On the prayer of Mr. NNB Chaudhary, learned senior counsel, let the matter be listed on 23rd.
CD may
23rd
be
of-
retained, then, Lord.
Hmm?
CD may be
C-
retained.
CD may be retained.
People don't know.
22, 23. Basically, my lord, it's a lady, my lord. She was arrested in, my lord, 26/5/2026, my lord. Well, probably today as on date, my lord, 57 days I am in custody.
He's saying the father custody is not required. Mr. B. Sharma,
Yes, Lord. Yes,
father custody is not
yes, yes,
required.
not required.
Same allegations.
And
Same this thing.
26 also, Lord.
One of the case, Lord, Belfort police station, Lord, registered, there, Lord, I have neither been included, arraigned as a witness or as an accused. Same allegation.
Item number 26 also,
Hmm?
same.
26 also.
26.
Same fishery, same
Same.
fishery.
22.
22, 23, 26.
22 is Mr. Borat, 23 is Mr. Chaudhary, and 26 is,
I'm not aware of who is there.
you are appearing, 26. Okay, these three matters, these three matters. I'll pass the order.
Problem.
Because FIR is quite lengthy, and that's why, lengthy detention.
Yes.
And
that one,
allegations are also lengthy.
FIR of 22, after 3 years, we have been apprehended by.
Lordship, there is a bail objection here.
Hmm?
If Lordship bail that it may help Lordship in passing the order.
But
There is a bail
objection is there.
There is a bail objection in the CD.
Mhm.
I will present it before.
But I'll just, because
Yes.
it may take little bit of time,
Yes, that's
s-
why.
the factually summarizing the things. That's why I'm not passing the order. I'll just pass the order.
All right.
All 57 days. No?
Count 57. Oblige.
57 days custody, लिखित हो उसमें।
Given 30 CD9.
Here also, my lord, the same issue is involved.
CD
but
not received.
CD is not there.
Hmm?
Same issue, my lord, in this case also.
Same issue of,
Earlier case, my lord, 24 hours.
same case.
No, this is different, this is intermediate quantity, my lord. He is in custody for 37.
CD has come.
CD not received, Lordship.
The CD hasn't come, let's wait for that, because that CD will be required because of timings. Okay, as Nawaz is present for the petition accused applicant, then you read B. Sharma for state, CD not received, let the matter be listed on 5th.
No, there is intermediate quantity, my lord. Can it be a shorter date, my lord?
50 is fine, I mean, 50 is fine. 50 is fine, not many days are there.
Big look. Complete record.
That is wrongly listed for my lord bail. It is ought to be come for motion. It has come for the first time, my lord.
Oh,
Why is it page 15, my lord? 55. I was arrested on 22nd of my lord June. Today 26 days behind the bar, my lord.
Mhm.
No. Why is it page 15, my lord?
Let the CD be.
crude oil, okay. Heard Mr. A.K. Gupta, learned counsel appearing for the accused applicant, also heard. How many are there? One accused applicant, also heard Mr. B.P. Sharma, B. Sharma, the learned APP for the state. This is an application you write, huh? Then you write, call for the CD, let the matter be fixed on.
From Tinsukia, Lordship, let it be, no, not him. 7th of August, Lordship.
7th August.
Much obliged.
Yeah, Lordship, the scan copy was called for, Lordship.
Hmm?
Scan copy was called for. The scan copy has been received, but there, Lordship, only the statement of the victim girl is there. And nothing else is there, Lordship. So, Lordship,
I just want to brought your lordship's notice in the FIR, my lord.
1 second, Mr. Kalita, 1 second.
in fact, Lordship, the 183 statement of the victim girl is also not there. So let the complete records come, Lordship.
How they are sending this, PCR like this?
Probably, Lordship, because the charge sheet was filed very recently. Probably, I'm not sure, Lordship.
Charge sheet was filed recently.
I will have to verify, Lordship.
If charge sheet is filed, then what is there?
Yes,
Is an AB application.
yes. That is why, Lordship, let them appear there. That is the
Huh?
better option, Lordship.
Charge sheet is, if charge sheet is filed, then you go there.
That is why, my lord, on the last occasion, my lord, your lordship, coordinate bench directed to produce the PCR. Lordship, may kindly see the page 19 of my FIR.
No, whether charge sheet is filed or not.
Charge sheet file.
The charge sheet file, you go there, what is there? You go there and, it's an AB application. Once charge sheet is filed, what will?
Petitioners, my lord, are on interim, but they accept the petitioner number 1, my lord. The POCSO allegation has been brought, my lord. Girl is apparently, my lord, she is 20 years old. She has written in the FIR herself, my lord. And boy, my lord, petitioner number 1, accused number 1, he is 23 years.
Where, no, the statement of victim is not there.
So let the statement come, my lord. I'm praying, my lord, only because otherwise, if he appear, my lord, as the POCSO is there, my lord, he will be put behind the bar.
Okay, we will call for this complete
Complete
TCR.
And
Okay,
Lordship will kindly mention along with the CD part as well as the statement of the victim. That part will mention.
Heard Mr. N. Kalita, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state, and Mr. T. Deuri for the informant. For the informant, full stop. Though certain documents, the scanned copies of certain documents have been received from the from the court of the district learned, from the learned court of district and session Judge Bozali, it is seen that the CD part of the TCR as well as the charge sheet is filed, na? Charge sheet is not not sent to the court. The court registry to send a reminder to the learned court of district and session judge, to session judge Bojali Patsala, to get the complete documents, including the CD part as well as charge sheet. Charge sheet, full stop. Let the matter be listed on 4th, 5th,
Lordship, let it be
AB
on
application.
10th, Lordship, because it won't takes time to send the requisition also, Lordship.
Okay, let the matter be listed on 10th. 10th of August, no? Registry to send a reminder to procure, huh? And you write like this, procure the scanned copies of the TCR, the scanned copies of the complete TCR along by including the CD part as well as the chassis, huh? Just like that. Yes,
Yes, I'm sorry, madam.
no problem.
Madam, this second petition, madam. And earlier, your lordship.
We have rejected earlier.
Yes, your lordship, at that stage, your lordships,
Hmm?
page 42. And your lordship rejected, madam, last point is at this stage. So now we have come, madam, after about more than 1 month time. Our case is, madam, one agreement was there between husband and wife. And as per this agreement, we could not annex idea, madam. Now we have annexed and it is available at page.
CD has come, Sharma.
No, the first time.
For
madam.
Oh, first time it has come. Motion.
So
Okay.
let the CD come, Lordship.
What agreement?
Agreement with husband and wife, madam.
What?
The allegation is that because I wanted to kill my son. This is the allegation. And your lordship will find
The agreement for
agreement with a husband and wife, the matrimonial minor maintenance case was filed. Then that was ultimately agreed and ultimately they have stated that let us go separately minor out of that. So that was done, there was agreement. And as per this agreement, minor matter is going on. Subsequently, minor hall because some property, etc. matter, some dispute took place between the two parties again. That is the FIR, it has given rise to the FIR. That's the up to the same,
but still you are out. I mean, after rejecting the bail, I mean, I mean, I don't know when.
But only your lordship because
1 month back.
something will come, 1 month already gone. It is something may come out.
Let us call for the CD and like next date we'll decide.
Lordship.
Hard Bisa a short date will give.
Right.
Hard Bisa HRS Chaudhary, the learned
Up to the
senior
half
counsel.
an hour.
This is the by so and so. Also heard Mr. B. Sharma, learned APV for the state. This is an application under so and so. Call for the CD, let the matter be fixed on
Six.
4th.
Fourth.
4th of August. But this will come before me only because I have rejected.
yes,
Okay, so 4th, this bench will not be there. So you can do a VC probably.
Madam?
You can do a VC. Because otherwise for 2 weeks, this bench will not be available. Or we'll have to place it after 2 weeks. That will be too long time.
That will do one.
VC you can do it. Correct. Then we'll keep it on 4. Okay, 4th is fine.
Any observation?
4th is 4th.
Fourth will be
4th you
Tuesday.
can do it. 4th is Tuesday. You can do it on 4th.
Any observation?
No, not required. You just put it before the registry, then they will, VC connection will be given, then you can take it.
Okay. Please wait a minute.
Only thing is that CD,
We'll produce it, Lordship.
you'll have to produce. Okay, we'll just come back in 5
Lordship.
minutes.
Uh, 32, Lordship, Petitioner is on interim, CD has not been received.
Case there is not received. Mr. H. Alamgir is present for the, learned counsel is present for the accused applicant. Let the matter be listed on
10th of August.
10th August.
CD received, Lordship.
Well, the petitioner is the owner of a vehicle,
Hmm?
Petitioner is the owner of vehicle,
Owner of a
vehicle,
vehicle.
There is a vehicle incident, took place, and my lord, the driver and the conductor were arrested.
Hmm.
Now, the petitioner, police searching the petitioner. The owner of a vehicle, even my lord, vehicles are already released.
Huh?
Vehicles are even already released.
Vehicle is released.
I am on interim, my lord,
He was on
and I have
interim.
appeared, my lord.
He was on interim, he has appeared, Lordship.
Let him go. Heard Mr. A. Khanikar, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. Then they write this is an application under section. Under section 482 of BNSS 2023, praying for granting PRS bail to the accused applicant in connection with Nagaon Police Station. Case number 383/2026 under section 61 in bracket 2 stroke 303 bracket 2 stroke 317 bracket 2 stroke 281 stroke 105 stroke 125 bracket B is capital B of BNS read with 196 MB Act.
And go to special.
The accused applicant is the owner of a dumper. The owner of a dumper which met with an accident whereby the informant's wife the informant's wife expired and their 6 months old children got injured. This court, the coordinate bench of this court by its order dated 162026 has granted interim pre-arrest bail to the accused applicant who is the owner of the vehicle. The learned counsel appearing for the accused applicant submits that in terms of the order dated 162026, he has already appeared before the investigating officer and got his statements recorded. The same fact has been confirmed by the learned APP for the state, taking into account the aforesaid, the interim pre-arrest bail order dated 162026 is made absolute and the instant AB application is disposed of.
Please, Lordship.
Is there is come?
People, Lordship, vigilance. Even vigilance. Special people.
Who is special PP? I Bothakur.
Team vigilance people. Forest.
You are there.
Yeah, my lord, I also represent wildlife, my lord. Well, after some time, my lord, I'll take instruction, my lord. Whether Bothakur also may be available, my lord. I'll call.
But it is seen that, the council, special counsel for the forest department, usually they remain absent. And please intimate Mr. I Bothakur.
Well,
Or who is the, I don't know, who is the senior counsel? This bench has seen that like whenever the matters are there, they are not present. We'll take it up after some time.
35 CD has been received, but nobody has been.
Lordship, I appear on behalf of respondent number 2, Lordship, and file ballot number, and I have objection, file objection, Lordship.
You want to file objection?
Bail petition is not furnishing to me, Lordship, so
None appeared for the accused applicant when the matter was called for. Mr. B. Sharma, the land APP, is present for the respondent number 1, and Mr. A. Ali is present for the respondent number 2, stroke informant. Mr. Ali submits that he wants to file an objection in the instant AV application. Let the matter be listed.
CD is available Friday also.
Let the matter be listed on Friday will be 24th.
no petition.
Let the matter be listed on 24th. You file whatever objection you want to file by tomorrow.
Petition was not received. Bail petition was not received till now, Lordship. That's why you have to.
Then we'll take it after some time. Let's see whether he comes. That person.
Yeah, he will
We'll,
come.
you just intimate him if you know him.
36. Charge submitted, Lordship.
You go and appear. Or Mr. Your name?
B. Datta, on behalf
B.
of
Datta,
R. Hawk.
B. Datta, the learned counsel, appearing on behalf of Mr. R. Hawk, the learned counsel for the accused applicants. Mr. B. Also heard Mr. B. Sharma, the learned APE for the state. This is an application under section 482 of BNSS 2023, paying for granting PRS bill to the accused applicants in connection with North Lakhimpur Police Station case number 180/180 of 2026 arising out of Kelmati Town Outpost GD entry number 221/2026 registered under section 303 in bracket 2 stroke 3 bracket 5 of BNS 2023, read with sections 13(1) of the Assam Cattle Preservation Act 2021, read with sections 11 in bracket 1 bracket small a bracket small d bracket small c of the Prevention of Cruelty of Animals Act 1960. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number
203/26 dated 17/7/26.
In view of the aforesaid, the learned counsel appearing for the accused applicants submits that liberty should be given to him to approach the jurisdictional court full stop. In view of the aforesaid submission, the instant AV application is disposed of with the liberty to the accused applicants to approach the jurisdictional court for appropriate relief, if so advised.
My lord, interim order is there. Accordingly, I am here before the IO.
Interim order is there.
Lordship,
Yes.
I may be interim order may be continuing.
Interim order so passed
Jamal, Lordship.
on 26/2025 is extended for 15 days from today. And during that time, the accused applicants shall approach the jurisdictional court. So 15 days extended, within that time you approach.
The PRS bail application, my lord. FIR at page number 8.
CD has come.
My lord, case that is available.
Lord, I have not been named in the FIR, my lord. FIR at page number 8.
Yes.
I'm the married sister of,
Hmm?
the married sister of my lord FIR name accused Durgeshwar Terang and Vinod Terang, my
You are the married sister.
sister.
Oh.
And my lord, to know the exact position of the case, my lord, kindly come to page number 17, my lord. My brothers have been arrested, my lord. Ground of arrest, my lord. Para number 1, my lord. Everything in detail has been mentioned here, my lord. My brother's wife has along with one Bison Inti, my lord.
Hmm?
My brother's
Which brother's wife?
Durgeshwar Terang, my lord.
Uh,
His wife along with one Bison Inti,
hmm.
my lord, who is the brother of the informant, my lord. Brother of the informant,
Hmm.
with whom wife of Durgeshwar Terang has along. And in search of both of them, my lord, and after knowing that informant and her husband gave them shelter, my lord, we went in search of both the wife and Bishon. And
What is the allegations against her?
My lord, due to assault, my lord, one person died, my lord. And my lord, she actively participated in the assault, my lord. And my lord, she arranged one auto, my lord, auto rickshaw, and took all the accused person to the place of occurrence, my lord. Then my lord beat that person, my lord.
But she is not named in the affair.
But ultimately in the investigation, my lord, her name cropped up, my lord. And my lord, my lord, evidences, my lord, very much there, my lord. And my lord, one thing, my lord, that postmortem report is not, my lord, that is waiting, my lord.
Oh, I mean, the killing is not disputed.
My lord.
Somebody has died is not disputed.
But my lord, 183 statement also taken of several persons, my lord. And my lord, all said, my lord, that
Our involvement is there.
eyewitnesses are there, my lord. And then, my lord, she actively participated. She assaulted the deceased person, my lord. Ultimately, my lord, one person died.
Fact, my lord. I went with my brother, my lord. It is a fact, my lord, admitted fact. After knowing that the deceased and this Bishon Inti, they have went to Jumkheti, my lord.
Yes.
We have returned back to home, my lord.
Yes.
And my brothers, they have stayed there, my lord. And there was a fight between them, my lord. It is the fact, my lord. And in that fight, my lord,
Evidence?
they were not.
That is there, my lord.
Yes, my lord. They were not armed with. They were not armed, my lord. With bare hands, man. So intention was never there.
What about bare hands? But it was hit. That person was hit by stick.
Yes.
Some sticks.
Yes, yes, my lord.
That is fact.
May I read, my lord? May I
Oh,
read?
no, I mean, what is the evidence against her?
Yes, ma'am. My lord, kindly, my lord, Durgeshwar and Meena.
Meena is she.
Yes, ma'am. Call me over telephone and ask me to accompany them in their search. I, along with some person, my lord, they went there, my lord, to place of occurrence. Then, my lord, he, along with other persons, namely Binod Teron, Rajen Tumung, Meena Terangpi, and some other persons, my lord, started to assault him with bamboo, lathi, on his head continuously for half an hour, and he started to bleed from his head and face. Unlawfully death, my lord, serious injury.
Okay, let her go. I mean, the brothers have been arrested. She may have been there. I mean, there was some case of elopement and all, giving shelter. In the heat of the moment, the brothers are already arrested.
Look,
She may have been there.
Actively
She
participated.
may have been there. Let her go. Heard, Mr.
H. Ali.
H.
Ali.
H. Ali. H. Ali, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of BNSS 2023 in connection with Bokolia PS case number 12/2026 under section 61 in bracket 2/126 bracket 2/103 of the BNSS of BNS 2023. An FIR was lodged on 18/4/2026 by the informant, namely Sika Inktipi, alleging intel that on 14/4/2026 in the evening around 3 p.m. Durgeso Terong, Binu Terong, sons of Noga Terong of village Danghap Singrai Terang Gaon Terangao, Dokmoka, came to the house of the informant in search of her husband Kamsing Ronghang. And when they were told that he was not at home and had gone to see the Jum cultivation, they went in search of him. Semicolon. That when the husband of the accused, the husband of the informant was returning home from the paddy field at around 5 p.m., the accused persons met her husband and assaulted him with a stick on his head and kicked him and thereby seriously injuring him. That the accused persons thereafter, that the accused persons returned to the house of the informant and told her that they had assaulted her husband and thrown her husband on receipt of such information. The informant along with others went in search of him and transfer of the husband of the informant and found him lying injured condition. Thereafter, he was taken to Diffu Medical Hospital. However, he died on 15/4/2026. On receipt of the FIR, the police registered Bokolia PS case number 12/2026. The learned counsel appearing for the accused applicant submits that the accused applicant is the sister of the two accused persons, and she did accompany the accused persons to the house of the informant, but when they were told that the informant husband was not at home, she returned. However, the brothers of her stayed back, and both of them indulged in some kind of a fight with the victim person. Full stop. He submits that there is no allegation against the accused applicant in the FIR. Full stop. The CD in the instant case has been produced. Mr. B. Sharma, the learned APP, on the other hand, submits that there are sufficient incriminating materials against the accused applicant, and her involvement has been prima facie found out in the offense that is in the offense as alleged in the FIR. After hearing the counsel appearing for the respective parties and on perusal of the case record, this court is of the considered opinion that at this stage the accused applicant should be granted the privilege of anticipatory bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Bokolia PS case number 12/2026, she shall be released on furnishing of a bail bond of rupees 20,000 with a surety of like nature subject to the satisfaction of the arresting authority, subject to the condition that the accused applicant shall appear before the investigating officer within a period of 10 days from passing of this order and shall fully cooperate with the investigation by making herself available as and when called for by the investigating officer. Next para, in terms of the aforesaid direction, the instant AV application is disposed of as allowed.
Hello.
34, my
But
lord.
your counselor, special counsels are
Special
not.
PP for wildlife, my lord.
Special PP, how many are there?
We are actually, Mr. Sharma is there, B. Sharma.
But
and
nobody
we are-
remains present. I have seen many occasions.
Well, sir,
Whenever the matter is
Yes,
called,
madam, I
nobody
apologize.
is there.
Well, I was.
Mr. Gogoi, you'll have to take care of this.
My lord, so it will be taken care of. My lord, in this particular case, my lord, he is not needed. I don't know why he is, I have instructions from the IO
But the forester has visited my premises, so.
That doesn't mean, my lord, he will be arrested, my lord. He's not needed in this case.
If not needed, my lord, then.
He is not required, then
He's not required, ma'am.
we allow this then.
Yes, my lord.
We'll allow
In
this.
fact, my lord, there's no case pending against him. Nobody has taken his name also.
But my lord, the thing is, the accused who was arrested.
Only forest people have gone to a place for some inquiry or investigation. Why you, I mean,
My lord,
you jump to the jump and come to a decision that you should go to the court?
no, my lord, actually what happened, the incidents was that, my lord, the 4 people who were at the forest area, my lord, they are the daily wage laborer. So, my lord,
So, I mean, should I record your thing?
My lord can record my submission.
Okay.
my
Okay.
lord,
Heard Mr. What is your name?
JN Swai, my lord.
Huh?
I am JN Swai.
JN?
Swai.
So the learned counsel appearing for the accused applicant, also heard Mr. D. Gogoi, the learned special counsel,
Still PP, my lord.
special PP for the
Wildlife Management.
Wildlife Department, State of Assam. This is an application under section 482 of BNSS, praying for granting bail, granting anticipatory bail, granting pre-arrest bail to the accused applicant in connection with Kulsi Forest Range case number. Then you write colon, offense number K stroke 05 of 2026 -2-27 under section 4 stroke 2024 stroke 25 stroke 60 of Assam Forest Regulation Act 1891. An FIR dated 12/5/2026 was lost. Anybody named in the FIR?
One person has been apprehended. Yes.
FIR has been lost before the Mr. Gogoi, usually if you file anything before the forest officer, range officer or whoever, you write it as FIR.
No, my lord, we call it offense report, my lord.
Offense report.
My lord.
Yeah, and an offense report has been filed by one Rajiv Roy, forest of Forest Office Kulsi, alleging that 4 persons are involved in cutting down trees. In terms of the aforesaid offense report, the offense report, the Kulsi Forest Range case number, the same case you write, case number, colon, offense number K stroke 05 of 2026 -227 under the aforementioned sections was registered. The learned counsel appearing to the accused applicant submits that forest officials have been visiting him, and therefore he has apprehension of arrest, and accordingly he has filed the instant anticipated bail application before this court. Mr. D. Gogoi, the learned counsel, has fairly submitted that the accused persons may not be required in the offense in the offense report, in the connected offense report, full stop, taking into account the submissions made by the learned counsel appearing to the respective parties. It is directed that in the event of arrest of the accused applicant in connection with the aforementioned case by the arresting authority, he shall be released on furnishing of a bail bond of rupees. So you have the power, no?
Yes, we have.
Power of granting bail
Yes,
and
ma'am.
everything. on, on furnishing my bail bond of rupees 20,000 with a security of like nature, subject to the condition that the, subject to the, does he required to appear?
No matters.
Subject to the condition that, subject to the conditions that, subject to condition that he will cooperate with the investigation, comma, if so required. If so required. In terms of the aforesaid direction, the instant AV application is disposed of. You are not required, you have unnecessarily come, but we have passed the note, whatever. Mm.
56.
Yes, but we have found out.
My lord, we have found out, my lord,
Mm.
and I am troubling my lordships with the relevant rules, my lord. It is very clear and specific therein, my lord. From the licensing authority to the C1 and H product is also very beautifully earmarked, my lord. First of all, my lord, I beg to draw my lordship's kind attention to, my lord, page number 65, my lord. My lord, may be pleased to find the page number in the bottom of this manual, my lord.
65.
65, part 6. My lord, is the sale of the drugs other than the homeopathic substances, the licensing authority, my lord. The state government shall appoint licensing authorities for the purpose of this part for such areas as may be specified. Now, my lord, in our areas, my lord, we have found out that it is the drug controller is the licensing authority, my lord. Their offices is situated at Lokhora, my lord. And secondly, my lord may be pleased to find that the C and C1 provision, my lord.
Yeah, where is that?
Yes, yes. First of all, my lord, I beg to draw my lordship's attention to page 33 of my bail petition, wherein the license is issued under form 21B. It is for CC1, my lord.
Page 33.
Yes, my lord, page 33 of my
This is form 21B.
form 21B, and that my lordship may be pleased to find under rule.
At page?
Yes, my lord. Page number.
Page number 218.
Yes, no, my lord, page number 225, my lord, form 21B, my lord.
225.
My lord. At top, my lord, license to sell, stock or exhibit or offer for sale.
No, this is not doubted, Mr.
My lord.
Yeah.
Now C and C1 products, which my lordship also wanted to know, my lord.
This is what I want to know.
And no, product or list tool was CC1. My lord, kindly turn to page number 287, my lord. 286 and 287.
Yes.
These are the, my lord, products which I am entitled to sell along with, my lord, Syrah solution of so and so. The entire list is here, my lord. Of
Correct.
course,
Where is the item that it has been seized?
my lord, this is under schedule H, my lord, and my lord may be pleased to find is at page 401, my lord. 401. Schedule H. Which one?
Codeine.
Codeine, my lord. Ek minute. At serial number 132, page number 402, my lord.
40?
For the next page, my lord, 402. Serial number 132, codeine. Now, my lord, I have to submit fairly before my lord, my lord. This, I just a small Roman 2 is there, numerical 2 is there. These two, my lord, what they have done, they have created another schedule, that is schedule H1. And that schedule H1 from this part, it has been shifted to the schedule H1 is at next page, my lord. My lord, may kindly turn to page 407.
There is codeine is there.
Yes, my lord, codeine is there. These are all prescription drugs, my lord. So, my lord, I am not selling any product which are not being licensed, my lord. Within the, my lord, my prescribed permission, I am selling, my lord.
Drugs and cosmetic rules are framed under what, which act?
Lord, under the Drugs and Cosmetic Act, my lord, if we, my lord, may be pleased to find from the very first page, Lord,
1940.
yes, my lord, the April 1940 Act of 1940, my lord. This act may be called the Drugs and Cosmetic Act 1940, and under the power prescribed under this act, rules are being framed. My lordship knows, my lord.
Roll to Papa Ram Ram, sir, roll to.
And rule starts, my lord, at page number 39, 21st of December 1945, my lord.
So your submission is that this is not a psychotropic substance.
No, my lord, this is not NDPS
Mm,
substance, my lord.
mm.
This is under the therapeutic medicine, my lord, used for therapeutic purposes, my lord. And it is can be prescribed by the doctors also, my lord. And the quantity or the quality, my lord, is also within the zone.
Mr. Goswami, then why NDPS Act has been invoked in this case?
Codeine is the, as per the NDPS, codeine phosphate is the banned drug, banned product also. That's why. Because FSL is found.
Where is that? Codeine, codeine is a product
In the
which can be sold only under
Well.
prescription. But it's not a banned product.
It's just least lordship.
Huh?
In NDPS Act, in the least codeine.
My lord, if it consumes in a large quantity, my lord, and even if we, my lord, approach the pharmacy for psychotic drugs, for, my lord, mental illness for the treatment, they do not provide us without a prescription, my lord. Very strict regulatory measures are there.
In codeine lordship, 10 grams of 1 kg lordship. 1 kg is commercial quantity. I mean, 1000 ml.
My lord, section 80 of the NDPS Act is also very clear, my lord. If just for a moment, my lord, I read over the section 80 says, my lord, the provision of this act or the rules made thereunder shall be in addition to and not in derogation of the Drugs and Cosmetic Acts 1940 or the rules made thereunder. So, my lord, if it is within the prescribed limit, that NDPS Act will not come into play, my lord.
This page number 286 and 5.
My lord.
So what is the relevancy of this?
Not, my lord, these are the,
It is schedule B, right? B1. No, 286, 286.
my lord, page number
285, 286.
Yes, my lord, I am.
So
coming.
it starts from 285.
Yes.
So it's basically schedule B, which provides for the fees of certain things. So how this is relevant?
Page number 285, schedule B1.
Schedule B1 is schedule B1. How it is relevant? I don't know.
No, my lord, this is for the fees for the test or analysis by the pharmaceutic.
No, correct. I
My
mean, so I don't think this is required. This is
No, in this case, it is not required.
not required. So your thing is that what the court wanted to know.
My lord.
Only thing is that you have been granted a license.
My lord.
License to sale and wholesale or whatever retail sale
My lord.
of drugs specified in Schedule C
My lord.
and Schedule C1.
C1, my
So
lord.
you just need to show me Schedule C and C1.
Yes.
So where is the C and C1?
My lord, we are also being authorized to sell, my lord.
No, that is different thing.
My
But
lord.
first is show me C and C1. If C and C1 contains codeine,
Codeine is Schedule 8 drug, Lordship.
Schedule H.
Schedule 8 drug.
correct. So for selling Schedule H,
My lord.
whether you have a license or
Yes,
not.
yes.
Where is that?
This is the license, my lord, is at page 34, my lord.
Page 34.
My lord.
Page 34 says license to
License
sell
sell,
stock
or
sale.
exhibit or offer for sale, distribute, wholesale
Hmm.
drugs other than those specified in Schedule C, C1 and X. My lord, all
So
other-
is it that you are licensed to sell everything except this? But otherwise,
My lord.
on the other hand, that by 33 license,
My lord.
page 33 license, you have been given this thing,
No.
license
No,
to sell
my lord,
this.
may I clarify?
Hmm.
May I clarify? My lord, by this page 33 license, I have been given the license to sell, my lord, the Schedule C1, Schedule.
So
C
two
and
licenses have been given.
licenses
So you have
have
been in fact given license to sell everything,
My lord,
almost,
my lord.
except X.
Except
Except
my lord,
X.
Exactly, my lord.
That is your case,
Yes, that is my case.
correct?
But Schedule H drug is a manufactured drug, and manufactured drug is definition is what it means, Lordship.
No, so it's,
NDPS Act, it is
Prescription drugs, my lord, these goods.
these schedules are from the rules.
yes.
Rules of these drugs and cosmetic rules.
Act, sir, 1940.
Correct.
The
And this license has been also granted under the drugs and cosmetic rules. Correct. Now there is drugs and cosmetic rules. There are certain schedules.
yes.
One license has been given to him saying that you can sell C, C1 and X. These three they have given.
Yes.
And another license has been given, none other than C, C1 and X. And the other license says that
License to sell
schedule C and C1.
other than C1, C1 and X.
So one license has been given for C and C1, and other license has been given for
C2
other
and
than
X.
those specified in C, C1 and X. So that means other than X, he has been given license to sell everything under the drugs and cosmetic rules.
My lord.
And drugs and cosmetic rules, there is a schedule called H. And in the H schedule, the codeine is there. So he has been given to sell codeine.
Manufactured codeine, Lordship, as per the SOP of the government, Lordship, the codeine part, which is a manufactured drug, that can be transported only for medicinal or therapeutic use.
Correct.
Now, Lordship, for that purpose, in my respective, there must be something, a specific license to that effect. I may be wrong, Lordship, but I don't think, Lordship, these two licenses will cover the Schedule H drug. Because Schedule H drug is, Lordship, the purpose for transporting, storing, everything is regulated, Lordship. It cannot be
No,
transported.
all these things are scheduled drugs.
Even, Lordship, it cannot be transported, Lordship, without the specific permission or the license, Lordship. So that part is, I am sure, Lordship, is not clear, very clear in this case, Lordship, because this does not mean, Lordship, that all other drugs may not include Schedule H drug, Lordship.
But it says like a license to sell, stock, exhibit, so and so.
Yes.
Drugs specified in
Yes.
Schedule C and C1.
Lordship will kindly.
Excluding those specified in Schedule X. It is very clear.
Yes, yes.
So other than X, C and C1 they are giving.
Yes. Yes.
Excluding those specified in Schedule X.
Yes.
Now, I don't know why they have written Schedule X excluding.
Lordship will kindly come to the definition of manufactured drug on the NDPS Act, Lordship. That is 2 subsection 11. Section 2, subsection 11. Roman 11.
Manufactured does, yes.
Lordship will kindly see, manufactured drug means A is not important, Lordship. B, Lordship may kindly see. Any other narcotic substance or preparation which the central government may having regard to the available information as to its nature or to a decision, if any, under any international convention by notification in the official gazette declared to be a manufactured drug, but does not include any narcotic substance or preparation which the central government may having regard to available information nature declared to be manufactured. This is codeine is covered under manufactured drug.
So I mean, yes, codeine may be covered and manufactured, but it is there in the schedule.
Schedule of Lordship.
Schedule of H.
Yes, yes, that's what I'm submitting, Lordship.
So
specific license has to be there for.
No, it doesn't say a specific license is required.
Lord, in the drugs and cosmetic rules also, my lord, under Rule 61, the forms of licenses to sell drugs has been defined, my lord. If my lord may be pleased to peruse, Rule 61, my lord, it is very clear, my lord. Again.
You all are saying it's clear, but it's not clear at all.
That's not.
My lord, is my learned friend, my lord, is now saying that for each another license, my lord. I have not
Forms of
seen.
licenses to sell drug.
My lord.
A license to sell, stock, exhibit, or offer, so and so. Then those specified in schedules C are drugs other than those specified in schedule C, C1 and X, and by retail restricted to so and so. This may be provided in license to a 20A. License in Form 20A.
My lord, if it is 20A, then it should be specific, my lord. Which drug?
20A shall be valid for a drug.
My lord.
And license to so and so, a license to stock, sell, stock, exhibit, or offer for sale, or distribute drugs specified in so and so, excluding this by retail on so and so. See, under this, there are only three forms.
My lord.
One is 20A, one is 20A, one is 21A,
21A.
and 20F.
My lord. My lord, 20A
20,
and
form
20B is also
21,
there.
21A
My
or
lord.
form 21B.
Now, our license form is also available here, my lord. That is
Your license form is 20B.
20B, my lord.
So 20B is for
21B. 20B is the general license, my lord, by which I am entitled to sell this H1 also, my lord.
20B.
20B, my lord. My respectful submission, my lord, is that I have not violated any licensing condition also, my lord, or neither the NDPS will not attract here, my lord. My limited understanding, my lord.
So it gives him license. Huh? It's covered by, because 21 B, and he has two licenses, 20B and 21. So 21B gives certain licenses which excludes drugs specified in schedule C and C1, excluding X. So I mean, X is only not covered, others are given.
Others are given.
And in this, the other certificate license says other than those specified in C, C1 and X. So for C and C1 and X,
Yeah.
there are different forms, licenses. And for this those things, there are different forms. So this will cover.
This will
again.
cover.
Hmm?
This will cover.
So you'll have to wait for some time. You can keep him. I mean, I'll pass the judgment order after the lunch.
Well, but I will be hearing. Obliged.
What we are submitting, Lordship, is that Lordship may not dispose of the matter.
Hmm.
If Lordship is inclined towards them,
Hmm.
then Lordship may call for the update city and let them appear if Lordship is inclined to pass that order.
We are considering them for interim only.
Subject
TD
to
has
verification-
come.
Subject to the verification of the document, because the IO may go into the investigation and verify these documents.
No, the documents that he has given. No, I don't think like because CD has come
To
already.
dispose of by imposing stringent condition, my lord, that I will whatever for the purpose of investigation, I will cooperate, my lord.
We will be placing for.
If I do not follow.
No,
the
no,
conditions-
I am only concerned about like there should not be any wrong interpretation.
yes,
And that is what I am concerned about.
Because, my lord, this
And
may-
other than that, I am not concerned about anything.
No, my lord, this may have a serious issue regarding the NDPS Act issue.
Correct.
There, so, my lord, it should not be wrongly interpreted that others should take the disadvantage. I am also concerned, my lord, but when the law governs the, my lord, for, allows us, my lord, then they should also be, my lord, finally can be disposed of, my lord. I will follow the, abide the any conditions, my lord, going to impose.
Okay, we'll see. I mean, we'll pass on.
Obliged, my lord.
It won't long it. Yes, Mr. Goswami.
Sorry to say, Lordship, one item was listed wrongly before another court. That is also SVPS case number 30 of 2023.
Hmm?
SVPS case number 30 of 2023. That was the Lordship was already, let's move item number.
Item number 22, 23 and 26.
That matter is
Paper has come, Lordship. 7 days custody.
Same thing.
Same case.
Okay.
That is come.
No, just-
And he has retired from service as an executive engineer of the agency.
Okay, we'll pass the order. This one also will pass the order.
Obliged.
This is item number
One, Lordship, the production is.
protection list.
The same case has been listed to end up.
Okay, that's why it has been transferred here. Okay. Heard Mr. A.R. Bhuya, the learned senior counsel, assisted by so and so. Also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 482 of BNSS 2023, paying for granting anticipatory and granting pre-arrest bail to the accused applicant in connection with Udhar Bond PS case number 45/2026, registered under section 22 in bracket C/29 NDPS Act 1985. The gist of the prosecution case that on 2/6/2026 at about 1 AM, complainant SI Kalidhar Thousand, Kalidhar Thousand of Udarband PS lodged an FIR at Udarband police station. on 162026. Lodged an FIR at at a police station with reference Udharban PS GD number 09 dated 162026 to the effect that on 162026 that at about 12:15 p.m. one telephonic information has been received by the OC Udharban Police Station, namely Inspector SI Imsing Timum, from a reliable source regarding storage stroke concealment of suspected NDPS substances by one Sahid Ahmed Borvia and his father Azizul Haq Borvia in their godown located at their house. Accordingly, the information has been entered by Udharban PS GDE number 09 dated 1062026. OC Udharban PS as an empowered officer under Section 41 of NDPS Act 1985 read with Assam Government Notification number EX/145/85/30 dated 25/4/1995 had authorized SI Kalidhar Thousand to conduct search and seizure at the godown of the aforesaid two persons. The police party headed by SI Kalidhar Thousand with certain other police personnels reached at Durganagar Part 5 on reaching the spot they found two persons identified as Azizul Haq Borvia. No, one person, Azizul Haq Borvia. Accordingly, search was conducted, and after a thorough search, they found 9 cartoons and certain loose bottles of suspected NDBS substance in bracket codeine cough syrup totaling to 1,420 bottles. Description of the seizure are as follows. Number 1, 8 cartons of trichloroidine hydrochloride and codeine phosphate syrup of 100 ml bottle. Batch number TBH Z 0039, all capital, comma, MFG, date 04/2026. Brand name Vincoff Plus, comma, each cartoon contained 150 bottles, totaling to 1,200 bottles. Number 2, codeine phosphate tripolidine hydrochloride syrup, comma, batch number HLA 37, MSG date 12/2025, brand name PBRX REX, all capital, of 1 carton containing 12 bottles, comma, 1 packet containing 100 bottles, totaling to 220 bottles. Number 3, 1 Realme mobile handset for 1 iPhone of Sierra blue color. The above named person, namely Ajizul Haq Borbia. The above named person, Ajizul Haq Borbia, was apprehended and taken under custody for further investigation. During interrogation, the apprehended accused person stated that his son Sahid Ahmed Borbia has brought the suspected NDPS items and kept in the godown. It was stated that they run the pharmacy together. Two persons were named in the FIR, namely Ajizul Haq Borbia and Sahid Ahmed Borbia. Next, upon receipt of the FIR, the police registered Udharban PS case number 45/2026 under section 22 in bracket C stroke 29 NDPS Act 1985. It is seen that by the order dated 23/6/2026, the aforesaid Ajizul Haq Borbia has been released on bail. Which court was this? Bail?
Court,
By the special court?
special judge and NDPS Silchar Milot, Kachar.
Special judge NDPS Silchar Kachar. Kachar. Mr. A.R. Bhuya, the learned senior counsel, submits that the accused applicant belongs to a respectable family and has no criminal background. He submits that accused applicant number 1 is a businessman and deals in medicine and wholesale business. And petitioner and accused applicant number 2 is a person working in his business establishment. The learned senior counsel further submits that the accused applicant number 1 is having a valid license to sell, stock, or exhibit in bracket offer drugs for sale or distribute by wholesale under the name and style of Messrs. Sahid Medicine Center by drug license number D stroke OL stroke CHR, all capital, stroke 6210 and D stroke OL stroke CHR stroke 6211 issued on 21/9/2022 under the drugs and cosmetic rules 1945. He further submits that petitioner that the accused applicant number 1 is having GST registration certificate by registration number 18 capital C O all capital no 18 COTP B8329A1 Z5. He submits that the accused applicant is maintaining all records about purchasing of medicines from different companies, and in the instant case also the petitioner number 1, the accused applicant number 1 has purchased the aforementioned seized 1200 bottles of Vincop Plus and 220 bottles of PBREX SYP from one Messrs. Simran Pharmacy having drugs license number 13 stroke WS TBL stroke 2023 7 X in bracket G stroke TBL stroke 2023 14 stroke WS TBL stroke 2023 and GSTN 14BRY PA7805H2ZK through a proper GST invoice by invoice number 09485 dated 14/5/2026. You take it from here. Huh? The learned senior counsel submits that the petitioner, the accused applicant number 1 is having been issued the license by the authorized by the authority as authorized under the Drugs and Cosmetic Rules 1945 has brought those seized items for the purpose of selling, and he has not involved in any illegal activity with the use of those purchased items, the purchased items, full stop. He submits that in the instant case, since the seized items are prescribed medicines under the Drugs and Cosmetic Rules 1945, which can be legally procured by a license holder and store the same for the purpose of selling or wholesaling, comma, he is not involved in wholesaling. The instant case would not have been filed or registered by the police authorities under the NDPS Act. Full stop. He submits that though codeine is named in the NDPS, codeine is a substance which features in the NDPS Act, but regulated purchase of regulated purchase of the seized items are not illegal under the provisions of Drugs and Cosmetic Acts 1940 and the Drugs and Cosmetic Rules 1945. He submits that the accused applicant number 1 is running the business for quite a while, and he has been purchasing medicines containing codeine, containing 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 tripropylidine hydrochloride and codeine phosphate, phosphate, and has been selling the same for the medicinal purpose. Full stop. He submits that in view of the aforesaid, since the accused applicant is not involved in any illegal activities of selling of any banned narcotics substances, the invocation of the provisions of NDPS Act in the instant case by the police authorities is illegal, and therefore the accused applicant should be released on bail. Should be given the privilege of pre-arrest bail in the instant case. CD in the instant case has been received and the same is perused. Mr. DP Goswami, the learned APP. What will be your submission, Mr. Goswami?
My submission is Lordship, the contraband recovered from his possession and our authenticity of the license should be verified, Lordship, whether this license or.
Okay, Mr. DP Goswami, on the other hand, submits that the contraband materials have been, a large quantity of contraband materials have been seized from the possession of from the godown owned by the accused applicant, number one, and the authenticity of the licenses which have been annexed in the instant anticipatory bail application are required to be verified. Therefore, he opposes the prayer for anticipatory bail of the accused applicants in the instant case. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties and has also perused the case diary as well as the provisions of law. It is seen from the license in bracket right annex 3 license in form 21B that the same is issued Same is issued on 21/9/2022 under the Drugs and Cosmetic Rules 1945, whereby a license has been given to sell, stock, or exhibit in bracket or offer for sale, or distribute wholesale drugs specified in Schedules C and Schedule C1 in bracket excluding those specified in Schedule X. It is also seen that the license is issued with the condition that the license unless sooner suspended or cancelled shall remain valid perpetually. It is also mentioned that the compliance with the conditions of license and the provisions of Drugs and Cosmetics Act 1940 and the Drugs and Cosmetics Rules 1945 shall be assessed not less than in 3 years or as needed as per risk-based approach. Another license under the aforesaid Drugs and Cosmetic Rules 1945 has been issued to the accused applicant, whereby the accused applicant was licensed to sell, stock, or exhibit, or offer for sale or distribute wholesale drugs other than those specified in bracket Schedules C, C1, and X. This license also has been issued and remain valid and shall remain valid perpetually if not cancelled earlier. From the above two licenses, it is seen that those licenses have been issued under the Drugs and Cosmetic Rules 1945, 45, and the licenses have been issued to sell stock or distribute wholesale various substances or items mentioned and either mentioned or excluded in the schedules mentioned there. is seen that under the provisions of Rule 59 of the Drugs and Cosmetic Rules 1945, the state shall appoint licensing authorities for the purpose of issuing licenses for such areas as may be specified. It is also seen that Section 61 provides for forms of licenses to sell drugs. The forms are Form 20 from 20A or Form 20B, as the case may be, as well as Form 21, Form 21A or Form 21B. And Form 25F or Form 20G, as the case may be. So it is seen, therefore it is seen that licenses can be issued in various forms for specific drugs as scheduled in different schedules, as provided in different schedules. It is also seen that Schedule H of Drugs and Cosmetic Rules 1945 provides for prescription drugs. Prescription drugs not defined. Prescription drugs.
Prescription drugs not defined.
What is prescription drugs? Mr. Bhuya?
Not. Prescribed means prescribed by rule.
The literary meaning we know.
My lord, my lord. Prescription means, my lord, the drugs which we, my lord, understand that those has been, my lord, prescribed by a
No, that
registered
we understand, Mr. Bhuya. I'm
But,
not
my lord,
asking
here
about
it
that.
is. My lord, perhaps it has not been defined under the NDPS, but the, my lord, the relevance can be drawn in from the cosmetic drugs and cosmetic rules, my lord.
Yes,
Lord, in page 71
Hmm.
of this, my lord, rules, rule 65,
The Rule 65 doesn't say so.
Subrule 3, my lord. The supply of any drug other than those specified in Schedule 10 on a prescription of a registered medical prescriptioner shall be recorded at the time of supply in a prescription register specially maintained for the purpose, and the serial number of the entry in the register shall be entered on the prescription. The following particulars shall be now, not exactly the schedule or those drugs which comes under this, my lord, prescription schedule. I don't think, my lord, it has been codified here also. Prescription.
There should have been somewhere. Something should have been there.
Stars, my lord, but stars say that there is no any statutory definition is found.
Hmm.
Only reference can be drawn in, my lord, that those articles under the rule 65 of the Drug and Cosmetic Rules 1945, conditions of license says that, my lord, provides that substances specified in Schedule H, H1 and X shall not be sold by retail except on and in accordance with the prescription of a registered medical prescription. And now this terminology, my lord, there is no, my lord, exact statutory definition is available, my lord. Prescription drug, that definition is not.
Okay, right, the last line. Schedule H and Schedule HN, H1 of the Drugs and Cosmetic Rules 1945, 45, which provides for prescription drugs, contains codeine as a prescription drugs. It is prescription drug. So the seized items, seized items which contains codeine as one of the substance is mentioned as a prescribed mentioned as a mentioned as a prescription with drugs, meaning thereby the same can be used under the prescription of a medical practitioner for medicinal purposes. Since the licenses have been granted by the authorities concerned under the Drugs and Cosmetic Rules 1945 for selling, stocking, and offering and distributing on wholesale the aforesaid substance codeine. The aforesaid syrups, aforesaid cough syrups seized contains codeine, and the the seized bottles of cough syrups have been duly and legally purchased by the accused applicant from a license holder for selling those cough syrups. It cannot be said that the accused applicant has illegally procured or stocked for the purpose of selling those cough syrups. It is also seen from the invoice annexed to the instant AB application in bracket annexer 5 that the seized number of bottles totaling to 1200 bottles of Vincoff Plus and 220 PBREX syrup have been has been purchased by the accused applicant in the name of Messrs. Sahid Medicine Center from Messrs. Simran Pharmacy located in Thobal, Manipur. It is also seen that Simran Pharmacy has also been given, is also having a license, that is license number 13 stroke WS dash TBL stroke 2023 7 dash X in bracket G stroke TBL stroke 2023 dash 14 stroke WS dash TBL stroke 2023. The aforesaid invoice dated 21/5/2026 has been duly signed by the proprietor of Simran Pharmacy, namely Ghulam Said Azad. This before Thobal, you write Lilong, Lilong Thobal, Lilong, Thobal. That place Manipur, Lilong, Thobal. Big spera. Taking into account the aforesaid materials and having prima facie found that the seized substances are prescribed substances under the Drugs and Cosmetic Rules 1945, which have been procured by the accused applicant on having active licenses issued to him under the Drugs and Cosmetic Rules 1945 by the authorized by the authority as described in the Drugs and Cosmetic Rules 1945. This court is of the considered opinion that the accused applicant can be given the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicants, in connection with in connection with Udharban PS case number 45/2026 by the Biden Aikama, he shall be released, they shall be released on furnishing of bail bond of rupees 1 lakh each with two sureties of like nature to the satisfaction of the arresting authority, subject to the conditions that the accused applicants, number one, accused applicants shall appear before the investigator within 10 days. Then number two, you write cooperate. Then number three, then not harm with the investigation. So then you write in terms of the aforesaid directions, the instant AB application is disposed of as allowed. I may upload the case, I mean order, maybe not today, maybe tomorrow. I'll just have a look into this. Because certain things, because prescription drugs and all these things are not described, not defined. There may be some references here and there. You should have come up with some case laws.
My lord,
Because I don't think like this is a very rare case or something like that.
No,
There
case
must
law-
have been many these things.
Case laws is there, my lord. The
then-
similar situations,
The similar situation, no, I'm talking about, say, I mean, the invocation of NDPS Act.
DPS.
And the substances are basically, I mean, prescribed under this drugs and rules. So some case laws are definitely there, maybe from the Supreme Court, maybe from the High Court. This court may not be aware because I may not have handled that many NDPS cases. But you could have come up and like, I think Mr. Goswami should have come, not now, yes.
Yes, no.
He should have come up with earlier. Some assistance was required. But he would no assistance, Mr. Goswami. He should have come up because matter was fixed. It was heard earlier. You are aware of this matter. In this kind of situation, you should come up with something. You should assist the court.
But in the meantime, if we find some doctor, I will furnish the same.
Correct, because these are very technical matters. Interpretations are also very technical. Correct. So some case laws wherein because I don't think this is a rare kind of a case. I mean, there must have been many cases. So I don't think it's very difficult to find out the cases. So we will take some time to upload it. No? I'll just check it properly, then upload it.
Oblige, deeply oblige.
See, Mr. Goswami, what I have felt, I have told very honestly before everyone. So please don't feel bad. I haven't also handled many NDPS matters. So I am learning. So that is the thing. I don't think today it will be possible to take up any hearing matters. So please, whoever have, hearing matters, you can take some dates from him and wait for the next date. Because I have some orders to be passed.
Yes.
We have many orders have to, 5-6 orders, it will take some time.
Maybe fixed a date.
Hmm?
Date maybe fixed.
You take the dates from him and give some dates in the month, in the month of August. The month of August. Not this month, but in the month of August. So you can take the dates from him. Your comfortable dates are in the month of August, starting from the first week of August. First week of August.
Petitioner is in custody for 185 days as on today. 185 days. The Lordship, FIR was registered under section 4 of the POCSO, 4 of the POCSO Act.
Hmm.
Not 4 Lordship, 6 of the POCSO Act. Lordship. the
And
petitioner-
anybody is appearing for respondent number 2?
No, Lordship, that last occasion Lordship was awaited for the appearance, although notice was issued, Lordship.
Then we'll have to engage somebody. We'll have to appoint somebody.
They were praying for default bail.
Default bill, Lordship.
That was
Default
the
bail.
In the
ground.
morning, default.
And another matter, we have kept it past,
Two.
for
This is that matter,
This is
default
the,
bail.
this is the matter.
charge sheet
Yes,
submitted.
yes.
Charge sheet submitted, yes.
Then you go there,
No, Lordship.
a default bail. No, another matter was there wherein charge sheet was filed and the council said that
No, it has been disposed
they
of.
didn't dispose of.
Then Lordship, we
Hmm.
filed the default bail petition before the court below
Hmm.
on 20 April 2026.
Hmm.
Whereas the learned court below has called for a report from the PI court
Hmm.
as to when the charge sheet was submitted before the court.
Hmm.
Lordship will find that report.
Okay, you are arguing on the time, filing and like not putting up
Yes, Lordship.
that matter.
Yes. Page number 41, Lordship may kindly see.
Hmm?
Page number 41.
Page number
41, 41.
41.
This is the report of the PI court. It says that Lordship, the charge sheet is dated 1/3/2026. And it was submitted before the court on 10/3/2026.
Page 41.
Page 41, second para.
Hmm. Yes, I beg to so charge sheet, so and so. Dated 1/3/2026 has already been submitted on 10/3/2026.
Yes, but that charge sheet was never put up before the court.
And charge sheet was filed within time.
Within time, within.
Hmm. Hmm.
In this case, Lordship, then Lordship may kindly see the dates. I was arrested on Lordship 18 January
Hmm.
2026.
18 January.
Yes, and remanded to custody on the same day, 18 January
18 January 2026.
2026.
And remanded on the same date
The same
to
day, to the judicial custody.
judicial
18/1,
custody.
2026.
18/1/2026.
Yes. Then Lordship, statutory period of detention of 90 days expired on 17/4/2026.
17/4
2026.
2026.
Yes, from 18/4, I was entitled to default bail, Lordship. My
Yes.
right to default bail accrued on and from 18/4/2026.
And charge sheet was submitted
Charge
as
sheet-
per this 10/3/2026.
Yes. Charge sheet is
And-
dated 1/3,
1/3 submitted on 10/3.
10/3.
10/3 means much.
Within time, Lordship.
Within time.
Within time.
Much within,
Yes.
within
But Lord-
time.
But Lordship,
But for a month, it was not put up.
for almost 2 months.
Almost 2
I
months?
will show from the record, Lordship. Then Lordship, I have annexed the Lordship entire order sheet right from the production till the charge framing order.
Hmm.
Nowhere it is mentioned that the charge sheet was put up
Hmm.
prior to date of that cognizance.
Hmm.
Lordship may kindly see page number, Lordship, 35. I have
35.
tell it with the record also, Lordship, this year. There is
Hmm.
the date on which the charge sheet was put up.
7/5.
7/5, after the statutory period was over.
7/5/2026, charge sheet was put up.
Put up. The second para, Lordship. Peruse the charge sheet filed by the IO under section 4 of the POCSO Act and section 65(1) of the BNS, along with so and so and so and so. Then after going through the aforesaid documents, that the cognizance was taken, Lordship. This is the first date on which the charge sheet was put up.
Hmm.
I have tallied with the Lordship trial court record also.
Hmm.
From before this date, no order is there indicating that the charge sheet was put up.
Hmm.
So charge sheet, although filed within time, it was put up before the court after the statutory period is over.
Yeah, that is your case, right?
Yes, in that regard, one judgment of our High Court.
That is I have also passed one judgment in Arunachal Pradesh. I don't have that judgment with me now. And the same with
This
this thing.
judgment was followed later on by other court judgments.
I have also followed this judgment. This is Justice Borua, right?
Justice Borua.
Yes. Yeah, I have also followed this, but I don't have the judgment with me now.
This is Lordship 2022 5 GMT 405. Para 38, 39.
Okay, that is your argument basically. I mean, it was put up, correct?
Yeah.
And let me hear him then. I got your point.
Yes.
Yes, Mr. Sharma, what is there?
Yes, the Lordship will kindly take note of the dates. Lordship has already taken note.
First
Just
is like 18 January,
yes,
he was remanded
he was
to
arrested.
judicial custody.
Yes.
Then 17/4, I mean, according to him,
90
this 90 days
Yes.
statutory period is
Correct.
over.
Correct.
Then charge sheet was dated
1/3.
1/3,
Yes, correct.
1/3/2026.
Correct, Lordship.
But it was submitted on
10/3.
10/3/2026.
Yes. Now Lordship will also.
No, it was submitted on not 10/3.
It was submitted before the court.
It was submitted, submitted,
Correct.
yes. It was submitted in the PI court.
One other date, Lordship may kindly note, that is the order of taking cognizance, that is on 7/5/26.
Correct.
In other words, Lordship, the charge sheet was perused on that day and cognizance was taken.
Taken, yes.
So the basic ground that they are taking is, Lordship, that cognizance was taken on that day. Before that, no charge sheet was not perused, was not put up, and
No, I mean,
Yes, yes.
scene or something
Correct.
like that, nothing is there.
Yes, Lordship.
Because, in PI code, there is a register they need to keep.
Yes.
And register
Lordship.
when this is received and
Yes.
whether they have put it before the court or not, all these records should be there.
Yes. Now, Lordship will kindly take up one order from the scan copy. I have flag mark, Lordship. That is order dated 23/4/26. I have put a flag mark. 23/4/2026.
That order I have also annexed.
Oh, they have also annexed, Lordship.
23/4. That is the rejection order.
23/4.
Yes.
23/4.
33.
So 23/4. Yes.
Yes, Lordship will kindly note the order.
Case
There,
33.
this plea was taken, and Lordship will kindly see paragraph number 5. In the backdrop of the submission of both sides, the court finds that the PI has reported that the charge sheet of this case has already been submitted before the court on 10/3/26. Admittedly, the accused has been languishing in custody since 18/1/26 for the alleged offense so and so, so and so. No. Yes, so this is the observation, Lordship, that it was submitted on 10/3/26. Let there be no confusion regarding that.
No, it was submitted on
Yes,
10/3/26, but where that nothing has been mentioned.
Yes, now Lordship will see
Before the court means like which court? PI
Yes.
court, this
PI
court,
court,
nothing.
PI court, Lordship. The report is also submitted. They have also annexed, that will, Lordship will find it page 41.
That also is already seen.
That I have seen. Yeah.
Yes, this is the report from the court itself, Lordship.
Ah.
Yeah. Now Lordship will kindly take up this judgment. Lordship will, I'm not going into every paragraph, Lordship. Lordship will kindly come to paragraph number 18. May I read, Lordship, slowly?
Yes.
None of the said cases detract from the position that once a charge sheet is filed within the stipulated time, so is our case, the question of grant of default bail or statutory bail does not arise. As indicated herein above, in our view, the filing of charge sheet is sufficient compliance with the provision of section 167(2)(a) Roman 2 in this case. Whether cognizance is taken or not is not material as far as 167 CRPC is concerned. The right which may have accrued to the petitioner had charge sheet not been filed is not attracted to the facts of this case. So this is my.
No, this is cognizance, but like Mr. I mean, the coordinate bench is distinguish.
No, there is a difference also, Lordship. I will place that, Lordship. Lordship has seen this.
This is cognizance part is fine, but
Because on that day when the charge sheet was put up, cognizance was also taken. So this is one of my submission. Next, Lordship will take another judgment. Here also, Lordship will kindly come to paragraph number 19.
paragraph
19.
19.
In this case, Lordship, every case has been discussed regarding default bail. The position now, Lordship will find at paragraph number 19 and one more paragraph. It is clear from the judgment of this court in Bhikamchin Jain that filing of a charge sheet is sufficient compliance with the provision of section 167 CRPC, and that an accused cannot demand release on default bail under 167(2). So that 167 Lordship is aware regarding the filing of 90 days or 60 days. On the ground that cognizance has not been taken before the expiry of 60 days. So that's what my submission is, Lordship. It is not necessary, Lordship, that the charge sheet has to be put up before the concerned court. Merely submitting it and there being an acknowledgement to that effect is enough. Cognizance need not be taken, Lordship. So cognizance is taken, Lordship, once the charge sheet is filed. The charge sheet is before the concerned court. Then itself the cognizance is taken. Lordship, will just go further, Lordship. The accused continues to be in the custody of the magistrate till such cognizance is taken by the court trying the offence, which assumes custody of the accused for the purpose of remand after cognizance is taken. The conclusion of the High Court that the accused cannot be remanded beyond the period of 60 days under 167, that is default bail, and that further remand could only be at the post-cognizance stage is not correct in view of the judgment of this court in this case that I have already placed. Now, Lordship will again come to paragraph number 27 also, Lordship. A close scrutiny of the judgment in Sanjay Dutt, Madhur Sheikh, Ravindran, all this case relates to default bail, would show that there is nothing contrary to what has been decided in Bhikam Chin Jain. In all the above judgments which are relied upon by other side, this court has categorically laid down that an indivisible right of an accused to seek statutory bail under 167(2) CRPC arises only if the charge sheet has not been filed before the expiry of the statutory period. Reference to cognizance of so-and-so is in view of the fact that situation where the application was filed after the charge sheet was submitted and cognizance had been taken by the trial court. Such reference cannot be construed as this court introducing additional requirement of cognizance having to be taken within the prescribed period prescribed under provision 2 162, failing which the accused would be entitled deferable even after filing with charge sheet within statutory period. So this is categorical, Lordship.
No, that is fine, but but thing is that filing means what?
Filing means, Lordship, taking note of the charge sheet.
Taking note of the charge sheet, taking note of.
Does not mean, Lordship, that cognizance has to be taken. That is not the.
But whether in this case, but note has
Yes,
been
that-
taken.
That I have already placed, Lordship.
How?
I am not.
That PI court, Lordship.
Huh?
It's not.
No,
cognizance.
PI court has received it.
Yes.
Okay, but that is fine, but it was,
not put up.
but it was not before the
Yes,
judge.
it was not put up.
So,
It's
so
not the
if
fault of the-
PI court defaults in putting up before the judge,
Yes.
then how he is going to get the, the default bail?
Lordship, then they will have to show, Lordship, that it was not before the concerned court. PI court means, Lordship, it was before the court itself.
Lordship,
but it
PI
was
court,
not put.
PI court doesn't mean before the, before the
court.
concerned court. PI court is somewhere where those documents will be submitted.
Yes.
Charge sheet will be submitted, and those documents will be
Transmitted.
recorded in the register that this document is received.
Yes.
Then PI court is going to transfer this to the concerned court
Lordship.
where the matter will be taken up.
Lordship.
Then only, I mean, it will be termed as.
This is the order of our coordinate bench also, Lordship.
Hmm.
Lordship, kindly bear with me and
Which paragraph?
yes, Lordship, here
Yes,
the
refer to this, okay.
yes, and Lordship will see the explanation that was given. I'm just placing it, Lordship. Paragraph number 9. In the aforesaid case, the basic question that had arisen was whether the submission of the charge sheet to the office would constitute substantial compliance with section. So this is the basic question, Lordship, whether submitting it before the office is sufficient compliance or not. Now, Lordship will consider. In the present case, however, it is an admitted position supported by record that after the charge sheet was submitted to the office of the Special Judge Pokso Tinsukia on so-and-so, upon completion of the investigation, the same was put up before the court on so-and-so and the following order was passed. Now, Lordship will see. The learned, this statement, this judgments, I'm not referring again. Paragraph 13, Lordship will kindly see.
That because I was the counsel and the factual situation was different also.
Section
one
167(2) of the CRPC so-and-so, read with section so-and-so of the authorized so-and-so. If the investigation is completed within the aforesaid period, no right to default bail arises. Such completion of investigation is provided by filing and placing the charge sheet, including through electronic communication before the magistrate court. Submission filing in the office of the court, PI office, is not sufficient in view of 173 so-and-so, 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 which mandates the forwarding of the final report to the magistrate empowered to take cognizance of offence involved. The evidence of such placement can be in the form of initial of the magistrate court on the charge sheet and register, but at the same time, a judicial order recording the putting up of the charge sheet is equally acceptable evidence of such submission. when such judicial order is available, there is no necessity to insist upon the signature or initial of the magistrate on the charge sheet and to register in order to prove the completion of the investigation. In the present case, the order dated so and so makes it evident that the charge sheet was presented before the court on that day, although it was filed earlier on 27/10/25 in the office of the order of the court. Had it not been presented, the learned presiding officer could not have recorded so and so.
So in this case, it will be different. In this case, I mean, see, the order of there was an order
Yes.
that it has been put up before this,
Yes, yes.
before the civil time.
Now, Lordship,
In the
that will
present
not
case,
be
there
the
is no
fault of
such
the
order.
prosecution, Lordship.
Hmm?
Prosecution will not be at fault, Lordship. We have
The
submitted it on
prosecution,
time.
prosecution is not at a fault.
Yeah.
But thing is that, I mean, PI court is also part of the prosecution. So PI court has a duty to place it before the court,
Yes.
concerned court within time.
Yes.
But they received it, but they did not put up before they have not transmitted it to the court,
Lordship.
concerned court. Then what happens? That
But-
is the situation. I think this other court,
But
court
Lordship,
bench is discussed.
Given to judge orders, Lordship can see Nobiul Islam one.
Now, Lordship, the
Lordship has
judgment
got it.
which I have referred to in the Supreme Court also, Lordship,
Mm.
it is stated that it need not be put up before the concerned court and take cognizance.
Now, that's what, now if you're saying so, whether that aspect was considered in this case or not.
Probably not, Lordship.
Huh?
These two judgment, Lordship, it is.
And whether if,
Here, Lordship.
and this judgment that you have referred to,
Yes.
this has been, this case was placed or not? The coordinate bench, I mean, Mr. Borua's judgment, this is Borua's judgment.
No, that was not placed probably, Lordship.
So if that was not placed, then it was not considered.
Maybe not considered. But in that case also, in Borua's case also, Lordship, there was no noting to that effect also, no report also, no judicial order also. So that is a different aspect, Lordship.
Lordship may kindly see the order passed by Honorable Justice Borua.
So noting is, I mean,
There was nothing.
in this case also noting is not there,
Yeah,
in his case.
It is Borua, Justice Borua's judgment, Lordship, there was no noting.
Though nothing was there. Nothing was there, no registered entry, nothing.
was there.
Nothing was
But
there.
here, Lordship, the PI court's report was also there. And Lordship will see the default bail, default bail is, Lordship, it will be his right if the charge sheet is not filed within time. But if
But what is the point of filing charge sheet if it is not put up before the court?
Lordship,
If it is lies in the court of the PI
Yes.
court,
yes,
then how does it help?
Lordship, because the whole contention is, Lordship, that cognizance was taken out there and
No,
it
no,
was not
cognizance
placed.
is not the contention.
The Supreme Court, Lordship, will see.
Lordship may kindly see para 37 of the judgment passed by Honorable Justice Borua. Para 37 will make it clear. Para 37, why the put up is necessary. This aspect of the matter can be looked from another angle. The judgment of the Supreme Court in the case of M. Ravindran Supra and the relevant paragraphs quoted here and above clearly shows that the section 167(2) of the code is integrally linked with Article 21 of the Constitution of India, and the obligation is cast upon the state under Article 21 of the Constitution of India to follow a fair, just, and reasonable procedure prior to depriving any person of his personal liberty. This valuable right under section 167(2) of the code cannot be made nugatory at the hands of the office of the magistrate, the court. It is also relevant herein to take note of the of allowing the office of the magistrate, the court, to receive on behalf of the magistrate, the court, may lead to manipulations, which would affect the rights of the prosecution as well as the accused, as the case may be. It is therefore the magistrate, the court, competent to take cognizance of the offence which is required under law to put the initial with date and seal of the court on the register maintained in terms of with the Assam Police Manual, so that there is no scope of any manipulation. So in that view of this court is of the opinion that the submission of the charge sheet before the office of the magistrate, the court, would not be sufficient compliance in terms of section 173(2) of the code, the so and so of the Assam Police Manual. And it is only when the magistrate, the court, competent to take cognizance of the offence, puts the initials in the charge sheet as well as in the register maintained the date and seal of the magistrate, the court, it would be that date on which the charge sheet has been deemed to have been submitted to the magistrate court. This is very clear why it is required to be before the magistrate also. And in that case also, Lordship, the charge sheet was placed before the court after the statutory period was expired, Lordship, although it was filed within time. Then para 39, in the instant case, it is seen that it was only on 7/6/2022 when the charge sheet in question was placed before the court, and there is no materials available wherein the special judge Karimganj had put an endorsement with initial and date as regards the date of receipt of the charge sheet. Consequently, therefore, 7/6/22 would be the date on which it would be deemed that the charge sheet was submitted before the special judge Karimganj in the instant case. And on that ground, Lordship, default bail was granted. And this ratio was, Lordship, followed. Lordship, I have given 2 orders, Lordship. Lordship, may kindly see first Nobiul Islam. Passed by Honorable Justice Midul Kumar Kalita, Lordship. Order dated 9/3/2026. And para 4, Lordship, may kindly see. Lordship is Gauhati.
Yes.
Mr. B.K. Mohasen, Learned Counsel for the petition submits that the petitioner herein is praying for grant of default bail under section 187(2) of the BNSS as the charge sheet was laid before the concerned judge in this case after expiry of 90 days of time. He submits that a petitioner was arrested on 4/11/2025 and 90 days got expired on 1/2/2026 and therefore as per the statutory provisions the petitioner was entitled to get default bail on 2/2/2026. Learned Counsel for the petitioner further submits that though the charge sheet was prepared and signed by the investigating officer on 23/1/2026, and it was forwarded to the court by the officer in charge, Bilasipara Police Station on 30/1/2026, as it would appear on perusal of the charge sheet. However, he submits that the charge sheet was placed before the learned additional session judge Bilasipara only on 5/2/2026, that is on the 94th day of the date of remand of the present petition. Learned Counsel for the petition submits that in this regard, the law has been made clear in a canon of judgments, which has been summarized by a coordinated bench of this court in the case of Samsun Noor that I have placed also. Samsun Noor, so and so. He submits that it has been laid by this court that the charge sheet would be deemed to be laid before the court on the date on which it was placed before the court, unless there is any other material to indicate contrary to that. He submits that in the instant case, a report was called for from the trial court by order dated 18/2/2026 as regard on which date the charge sheet was placed before the said court. He submits that the report in that regard has been received by this court and the report indicates that it was put up before the additional session judge Bilasipara on 5/2/2026. He further submits that under such circumstances, the petitioner is entitled to get default bail as the charge sheet was placed before the concerned judge magistrate after the expiry of 90 days. Then Lordship may kindly see.
How can you, Mr. Sharma, how can you make a person, I mean, guilty or he's made to suffer only because charge sheet was prepared, but it was not laid before the court, before the concerned court, and in between 2 months have passed, and you take the date when the matter was placed before this. How he's to be blamed for that?
Lordship, because the judgment which I have referred, Lordship.
That judgment says that in the judgments that you have referred,
yes,
that this particular question hasn't come up. It says about when the charge sheet has been filed.
Yes.
Once charge sheet has been filed, there is no default bail. That concept is very clear.
No, Lordship.
And that concept is clear, but as to when it will be termed as filed,
yes,
that is not discussed here.
That is discussed, Lordship.
Where?
Lordship will
Can you show me where?
Yes, Lordship will kindly bear with me. Lordship will kindly come to paragraph 18 of this judgment. Suresh Kumar.
I'm holding this. I'm holding this.
Lordship, paragraph 18 I have already pointed out.
None of the said cases detract from the position that once a charge sheet is filed within the stipulated time, the question of grant of default bail does not arise. We don't have any issue in this. As indicated herein above, in our view, filing of charge sheet is sufficient compliance with the provisions of section 167 2A2 in this case.
Yes.
So filing of the charge sheet, filing of the charge sheet.
Yes.
Now, whether cognizance is taken or not is not material. Correct. So in this case also, if the learned session judge or any magistrate would have perused this, mentioning that he has seen this, then whether he has taken the cognizance, he can put it up for a different date also. But at least he has seen this charge sheet. That means the charge sheet is filed.
Yeah. Now,
taking cognizance can come later on also. And on the particular date, he may not take cognizance. He may postpone it for another date.
Lordship will kindly continue, Lordship. I will continue, Lordship.
Correct.
Yes. Whether cognizance taken or not is not material as far as 167 CRPC is concerned. The right which may have accrued to the petitioner had charge sheet not been filed is not attracted to the facts of this case.
That case.
Yes. Merely because sanction had not been obtained to prosecute the accused and to proceed to the stage of 309 CRPC, it cannot be said that the accused is entitled to grant of statutory bail as envisaged under 167 CRPC. Now, Lordship, I am reading. The scheme of CRPC is such that once the investigation stage is completed,
Mm.
the court proceeds to the next stage,
Mm.
which is the taking of cognizance and trial.
Mm.
An accused has to remain in custody of some court.
Mm.
During the period of investigation, the accused is under the custody of the magistrate before whom he or she is first produced. During the stage under 167(2) CRPC, the magistrate is vested with authority to remand the accused to custody, both police custody and or judicial custody for 15 days at a time, and to a maximum of 60 days in cases of offense punishable for less than 10 years and 90 days where the offenses are punishable for over 10 years or even death sentence. In the event an investigating authority fails to file the charge sheet within the stipulated period, the accused is entitled to be released on statutory bail. In such a situation, the accused continues to remain in the custody of the magistrate till the time as cognizance is taken by the court trying the offense, when the said court assumes custody of the accused for purposes of remand during the trial in terms of 309 CRPC. The two stages are different, but one follows the other is to maintain a continuity of the custody of the accused with a court. Having regard to the above, we have no hesitation in holding that notwithstanding the fact that the prosecution had not been able to obtain, so this is not relevant. So what I'm harping on, Lordship, is once the charge sheet is filed, Lordship, he is under the custody of the court. Investigation stage is over, and the next stage itself is cognizance, Lordship.
No,
There is
correct.
no other stage, Lordship.
No, correct, but,
So
but
if
you have some water or something.
yes, on to this one. So, Lordship, if charge sheet is filed, but cognizance has not been taken, which is itself the next stage, Lordship. So that is not the indivisible right of default bail, Lordship.
No, correct. I mean, cognizance is not which is really discussed in this case.
Yes.
What is important is that whether a charge sheet has been filed or whether the concerned court has seen it or not. If concerned court has taken note of this, that it has been filed, then that will be the date when that will be the date taken of to be to be the date of filing the charge sheet. So now thing is that the filing of charge sheet means what? Filing of charge sheet means the concerned court because this has to be filed before a court, not before the PI court.
Lordship.
So this it has to come to the court. So whether the court has seen it or not, because you file it before the PI court and PI court has received it, he has mentioned it in the diary, that doesn't make any sense, doesn't make any difference, but it has to be seen before, it has to be filed before the concerned court, whether that has been filed before the court or not. If it is filed before this court and court has seen it, then it will be a date of filing. But if it is filed before the PI court, but it is not transmitted to the concerned court, then that is not a effective filing. So that is that is the question which has been discussed in the other case.
Lordship, for an example, Lordship, I'm just praying, Lordship. If Lordship a charge sheet is filed before the PI court in a given situation, and the court the charge sheet is put up before the concerned court, Lordship. On that day, Lordship, what will be the order that will be passed? That is the order of cognizance.
That will depend on many things.
In my respectful submission, Lordship, that will be the order of cognizance.
Usually it will be that of cognizance.
Lordship.
Generally it will be that of cognizance.
When the charge sheet is filed, that itself is the order of cognizance, Lordship. So, Lordship, in this case, the Supreme Court has taken that view, Lordship, that cognizance is not the issue, Lordship. It doesn't mean, Lordship, that will be the date of filing.
No, but see this that is what I mean. Now this is a statutory right
Lordship, yes, I agree on
to
that,
a
Lordship.
person,
Yes,
right?
yes.
Now, if a PI, if a investigating officer says, I have completed the investigation 2 months back and I have submitted to the PI court,
Lordship.
but the PI court did not forwarded it to the concerned court,
That is the
and a
case.
concerned court has seen it after 2 months. Are you going to take away 2 months of valuable time? Can you take away 2 months of valuable time of a person? Is it whether it will go with the Article 22(1)?
Lordship, that is not my intention, Lordship.
No, no, I'm
Actually,
just asking you.
no,
We
that
are
is-
just discussing, deliberating,
Yes,
nothing.
Lordship.
I understand that this is not your,
Yeah,
this,
Lordship,
I mean, these are not, but we are trying to understand like what the courts are saying.
Lordship, what
So whether that will not be violative of this thing, I mean, a person's fundamental right.
Lordship, such is the law in my respectful submission, Lordship, because this judgment as well as that judgment, Lordship, has found, Lordship, that cognizance is not the criteria to adjust, Lordship, the date of filing.
But where,
Cognizance, Lordship.
in this case, Mr. Borua's judgment,
Yes.
Justice Borua's judgment,
Lordship, there nothing was there. That is a different issue, Lordship, because there was no note from the PI court, no order, nothing was there.
no,
Lordship.
but this issue has been decided by him.
Probably, Lordship, but it was.
Yes,
placed, Lordship.
the issue has been decided by him.
But
It has
in
been followed also, Lordship. by
that's
the
a
Nane court
different
judge.
issue, Lordship, because in our case, the situation is different, Lordship. Here, Lordship, no fault can be given to the prosecution, Lordship, because we have done our job, Lordship. We have filed the charge sheet on time, before time, Lordship.
In that case also, Lordship, charge sheet was filed within time. It was placed after that period. Obiul Islam, it is followed, Lordship. In the other order, I have also given Jaidul Islam. The same ratio has been followed, Lordship. In this case, cognizance is not the issue, Lordship. It was placed after 2 months of Lordship filing.
So, and like Mr. Sharma, your additional PPs who are there, you are also not properly, I mean, you don't have probably a group wherein you share the cases and all, whichever judgment has been passed. Do you have a group? WhatsApp group or whatever?
Lordship, that we also have a group, Lordship, and
Then whether you share this kind of, then,
we
then,
share-
see,
we
I mean,
share also,
see,
but-
Mr. Sharma, if you are submitting these two cases before me, those cases should have been submitted before those two courts, before passing of any of the orders.
that should have been done.
Then, and then you are allowing one court to pass one order and allowing another court to pass another order. So how it will be done? So you should have a proper distinct of sharing your, this thing. These are important issues.
Yes, Lordship. The
You should
fault
have
is
a,
ours,
you
Lordship.
should have a group
Because the
wherein
fault is
you
ours.
share these
Yes.
cases, that these are the cases we need to place. Now see like this case, this case, there is no mention of this case, I mean, these two
That
Supreme
is
Court
our
cases.
fault, Lordship.
Then
because-
if Supreme Court cases are not mentioned, then the order has been passed.
Yes, Lordship. I understand, Lordship. That
And
is
you
our
cannot
fault.
expect the judges to know each and everything. Each and everything, whichever has been passed under the
I'm not
world.
going into that, Lordship.
No, no, I'm just asking, I'm just saying. So if those cases are not placed, then how it will be decided? So now I can see there is a different PP, additional PP appeared here, there is a different additional PP appeared here, but there is no,
That is our fault, Lordship.
hmm?
That is our fault.
So, I mean, I don't know, that we'll have to look into this, I mean, this aspect, whatever.
173(2) is very clear, Lordship. 173.
We will fix it on this thing. Friday and we'll see,
Lordship,
we'll go through it.
I will also try to get if there are some.
Because see, I mean, this case was, why I'm saying so, this case, I'm aware of this Justice Borua's case.
2020.
And this case, because a senior advocate was in fact engaged as an amicus to assist the court. And after a lot of deliberation, this judgment was passed. Correct? So I don't know now how these cases are left, if these cases are not discussed. That is why in the, I mean, that is what I am saying, I mean, certain cases, I mean, you'll have to be a little bit prepared, I mean, the APPs, correct?
Yeah, I understand.
Now, I appreciate your effort that you have come up with these two cases, you are trying to distinguish the cases. It's highly appreciable job you have done. But thing is that like, this has to be properly circulated so
yes,
that
there are
others
some-
also do the same thing. Others also do the same thing because these relevant cases are not placed before the court. And simply you,
In that aspect, Lordship, there are many things that I would like to state before Lordship, but I cannot do it in the open court.
no, that I understand, that maybe not there. I mean, always it cannot be, everybody cannot be equal.
Yes.
Everybody's wisdom is different, everybody's this thing is different, but at least sharing can be done. What I'm saying that the sharing,
done.
sharing among the.
Sharing is done, Lordship.
Ah.
We have a group, we share our judgment and only one or two, let me say, Lordship, two of our APP only share judgment.
Ah.
In very
So it
simple
should be
terms.
shared so that, because if you are, I mean, now you are relying those two Supreme Court cases. Those Supreme Court cases may not have been discussed in the
Correct.
other judgments. So judgments are passed like
now also is not there.
It was,
CD is already available, Lordship.
okay, none appeared for the accused applicant when the matter was called for. Though Mr. B. Sharma, the learned AP for the state is present.
Yes.
Additional PP for the state is present, as well as Mr.
Ali.
A. Ali for respondent number 1, respondent number 2, full stop. Let the matter be listed.
Friday CD is available.
Huh?
Friday CD is available.
Okay, let the matter be listed on Friday.
There is a office note, Lordship. Service is not complete, probably, Lordship.
Okay, service is awaited. Service is awaited. Service report. Service report is awaited. Let the matter be listed on 4th July, 4th August. And then write, please write none appeared for the accused applicant when the matter was called for.
There is also office note, Lordship. I'm not sure what the office note is.
But Peltier was called for, Peltier has been received.
Hmm.
Charge sheet has been submitted in this case. All the offences are magistrate tribal manner. And manner, the injury report also turned out to be simple manner. They will face trial manner with lots of opportunity.
Injury report where?
I have phlegma. Report I did not see, manner, but that is mentioned in the list of documents. It will be simple. This was mentioned. Equal one to production national B. Good job. Medical report na
Medical report is not there.
Medical report is not there.
Medical report is not there. How then?
But in the list of documents, it says that it is simple. What should they call for a medical report?
We call for we will wait for some time.
Yes, yes.
Hmm? Then you write, heard Mr. S. Das, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned AP for the state. It is submitted that it is submitted before this court that charge sheet in the instant case. Is there any number or something? Charge sheet is there. Charge sheet is there. Then only medical report is required. It is the TCR in the scan copy of the TCR in the instant case has been received. However, the same does not include the medical report. A medical report, full stop. Accordingly, registry is directed to procure the medical report in connection with what is the case number? Sukchar PS case number 28/2026. PRC is what?
219 of these.
219 of 2026 from the court of the
Judicial magistrate.
Chief Judicial Magistrate.
Salmana Manka.
It is Chief Judicial or Judicial Magistrate first class?
CGM will be there.
Huh? CGM. Harsingmari.
Yes. District is South Salmana Manka.
South Salmana Mankasa. Mankasa. Release the matter. Release the matter after. Release the matter on.
Next week.
Next week will be possible. Release the matter on. Okay, 5th of August.
30th or 31st of July.
Okay, 31st of July.
Thank you.
Today will not take up. There will be no time. Okay, some other day will. When do you want?
I need it next week. I need it.
Huh?
Next week, Lordship.
Heard Mr. SR and Ase, the learned counsel for the accused applicant. Due to the paucity of time, the paucity of time, the matter could not be taken up. Let the matter be listed on 31st.
38 orders.
What is IA for?
My lord, IA for condonation of dilemma. My lord, as per office note shows, my lord, the respondent wife, she has not appeared. My submission before his lordship, my lord, I may be allowed to take justice service or speed post, my lord. Once again, I will take notice. That's because, my lord, the present petitioner is a BSF person, and he is suffering from his
No, I mean, ID card hasn't been received.
not received, my lord.
And then we'll have to wait for some time.
My lord, may I say, my lord?
No, we'll have to wait for some time. I mean, justice service, I mean,
Actually, moreover, my lord,
no, it was, when did you take steps?
My lord, I am ready to take justice service, my lord. My lord, you lord should kindly allow me.
Heard Mr. A. Manab, the learned counsel, appearing for the accused applicant, appearing for the applicant. Also heard Mr. K. K. Das, the learned accused for the state. Office note dated 17/7/2026 reveals that neither AD card nor any unserved notice in respect of respondent number 1 has been received back by the section till date. The learned counsel appearing for the petitioner submits that he should be allowed to take service he is allowed to take service by way of dusty mode on respondent number 1. Taking into account the fact that the notice has already been was issued way back in 18/6/2026, the prayer for dusty mode is allowed, and accordingly, it is directed that the petitioner, the petitioner said take petitioners shall take a service of notice by way of dusty mode, and thereafter file an affidavit in proof of service of notice upon respondent number 1. Let the matter be listed after 2 weeks. Take until dusty mode.
Obliged, my lord. Highly obliged.
Lordship, due to some inadvertence, steps could not be taken. Lordship will take steps. We are not on slate.
Okay, steps, the learned, your name?
The Lordship.
It allowed the learned counsel appearing for the petitioner submits that inadvertently the steps could not be taken by the petitioner, and he should be allowed to take fresh steps. He should be allowed to take steps. Next para. The petitioner is allowed to take steps by way of speed post within a period of 3 days from today. Let the matter be listed after 3 weeks.
Your Lordship.